My Lord, Lordship, my Lord, I have filed an additional affidavit. My Lord will kindly have a look. Firstly, I wanted to bring to the notice of the Lordship that no, my Lord.
Let the matter be listed on Monday as it is submitted. That an additional affidavit has been filed by the petitioner, bringing further information and documents on which he seeks to rely on. Copies have been served to the respondent. Considering that there is an interim order in the matter, let the matter be listed on Monday, 11/3. Interim order passed earlier will continue till 11/3.
My Lord.
And my Lord will consider on the interim extension.
On the next date fixed, for extension of the interim order passed, court will examine the matter and pass effective orders.
My Lord.
Deeply.
Yes.
May it be your Lordship, I have received an instruction, Lordship. The department has written to the personal department as well as the election commission regarding whether this scheme has been adopted by the government of Assam or not. The views yet to be received from the concerned department. So department praying for 10 days more times to complete the instruction, my Lord.
Learned Standing Council submits that that the Cooperation Department has sought for instructions from the Office of the Personal Department, Government of Assam, from the Personal Department, Government of Assam, as well as the Joint Chief Electoral Officer, Assam, Election Department. The Learned Council on instruction submits that matter be deferred for another 10 days, enabling them to complete the instruction. No objections are raised by the Learned Council to the petitioner to the prayer made. Accordingly, matter be listed after 10 days. 18th.
Lordship, I'm deeply
Well,
obliged.
order passed earlier will continue till the next date.
Lordship,
Grateful.
deeply obliged, my Lord.
Yes.
Maybe the Lord. My Lord, here is a case where the suspension, my Lord, it's a prolonged suspension. And my Lord, the period is, my Lord, about more than 3.5 years, my Lord, from the date of the suspension. Now, my Lord, before proceeding, my Lord, further, what I respectfully submit that normally in suspension order, suspension cases, my Lord, your Lordship would normally not interfere, except, my Lord, where there is a case where the, my Lord, authority issuing the suspension order, my Lord, is incompetent. Here, my Lord, my submission would be to show your Lordships that the register of Disciplinary University, who had passed, my Lord, the suspension order, is neither, my Lord, the disciplinary authority, nor the appointing authority, my Lord, nor, my Lord, the, my Lord, competent authority to pass the suspension order. So on that count itself, my Lord, the suspension order is illegal, my Lord, and without jurisdiction and void ab initio. And secondly, my Lord, there is an ordinance under the Disciplinary University Act. And in terms of that ordinance, my Lord, the suspension order has to be passed. These conditions, my Lord, and the circumstances are prescribed. Now, the suspension order is also the horse, my Lord, of that ordinance. In that count also, my Lord, the suspension order goes. And your Lordship will find, astonishingly, my Lord, during this period of 3.5 years, there is no endeavor on their part, my Lord, to review, my Lord, in respect of the suspension order, whether it has to be, my Lord, revoked or, my Lord, the suspension order has to be continued. There was an order of this honorable court, my Lord, directing the Vice Chancellor to, my Lord, consider whether the suspension order can be revoked or not. Even after the order passed by this honorable court, the register had considered, my Lord, the case of the petitioner, and thereby, my Lord, on some flimsy ground, which is wholly untenable, my Lord, proceeded to say that the suspension order will continue my lord, until the disciplinary proceeding, my lord, culminates. And that, my lord, by that, my lord, they have placed me under suspension for an indefinite period. My lord. So therefore, my lord, my respectful submission is, lordship will consider this case. If your lordship finds that the authority is totally incompetent, lordship will interfere. My lord. On the face of it, I require no argument, my lord.
What was your ground in the earlier round of writ petition?
Yes, my lord, my ground was that my suspension order has not been reviewed.
What was put to challenge? What we want to know in the earlier writ petition?
Uh,
4698.
My lord, perhaps in that case, my lord, I was not, my lord, representing the petitioner in that case. In that case, my lord, perhaps this ground, which I have taken now, that was perhaps not, my lord, present in that case. But even then, my lord, if your lordship find that the authority is incompetent, then the order is rendered, my lord, void ab initio. My lord. And there are judgments to show lordship is aware.
Anyone for the respondents?
But their name is shown, my lord, Dibrugarh University.
Yes, yes.
Yes.
Our Mazumdari on likes in part one.
Can be helped. Can be helped.
My lord, I'll start, he may come, my lord.
After some time.
We'll issue notice today. What else do you want?
That is correct, my lord. But
What do you want today?
my lord, in fact, your lordship can take up, my lord, because, my lord, your lordship will see, I will not enter into the merits of the case. If the Dibrugarh University can show.
Whatever it may be,
My
but we need to hear the other side.
Correct.
Some,
My lord, the only
some
point,
opportunity, if not for a matter, the grounds that you're urging, I think the notice would be proper. But even if we don't issue a notice, we'll have to give him some opportunity.
correct, my lord,
What orders do you want today?
that in that case, my lord, what I was contemplating, because, my lord, no argument is necessary to show your lordships, my lord, that the register is incompetent. Because he is neither,
No, your suspension order, when was it passed?
it was passed, my lord, on 6/7/2020.
2020.
2020, more than 3.5 years. My lord.
So
Yes. I understand, my lord. I can wait for another 7-10 days. Lordship will, my lord, fix this matter for admission hearing, my lord, as per your lordship's convenience. Lordship may issue notice today, but by that time, my lord, they have to file their affidavit.
why are you prevented from taking part in the research for PhD and all that?
Absolutely, my lord. This is one of my ground. There is, my lord, no connection, reasonable nexus, my lord, with placing my lord, me under suspension, my lord.
When is it by way of an order?
Yes, my lord, that
Well-
is by way of an order. That is why also, my lord, I am prejudiced by the suspension. That order your lordship will find immediately after the suspension order, they have passed this order, my lord. PhD order at page 53, my lord. And this is also, my lord, without jurisdiction. If your lordship comes to page 53, Annexure 9, as approved by the Honorable Vice Chancellor, Dibrugarh University, the PhD registration of Sri Dhrupadi Chaudhary, Research Scholar, Department of Mathematics, Dibrugarh, is hereby suspended. This is without jurisdiction. They cannot, my lord, tinker with my lord, educational persuasion, my lord.
Is it provided in some statute or some?
No, my lord. No,
No.
no, ma'am. Because this is guided by UGC regulations. Ma'am. They cannot do so.
So you are not participating there.
No, my lord.
Okay, heard direct counsel for the parties issue notice. Returnable 3 weeks.
My lord, can it be shorter date, my lord? I leave it to your lordship, my
All
lord.
right,
But
2 weeks.
yes,
2
2 weeks, my lord.
Let the matter be. Who's appearing for respondents? All the respondents.
My lord, the standing counsel is appearing, my lord.
Mr. Mazumdar,
Yes, my lord.
have you been served with a copy?
Yes, yes. Their name is shown, my lord. We have
Sir,
served the
R.
copy, my lord.
Mazumdar, learned counsel, appears on behalf of all the respondents as the respondents are represented by counsel notices are waived, our extra copies be furnished within a period of 1 week. Can you do it within 1 week?
I can do within 2 days, my lord.
Okay, we're giving you 1 week.
My lord.
Let the respondent complete their instructions and file necessary affidavit if so advised. Matter be listed again on 27th
My lord.
March.
My lord, lordship can an observation on the next date, having regard to the facts and circumstances, endeavor would be made, my lord. If they don't file the affidavit, they'll again take time, my lord. And I have attributed malice also, my lord. Absolutely, my lord,
So
to prejudice
therefore,
me, my lord.
That mere observation will
No,
not be
lordship will
helpful.
say, my lord, that they will file the affidavit. In absence of the affidavit, your lordship will proceed, my lord, having regard to the facts and circumstances.
We'll see on the next day, not today.
Correct. Obliged.
Let it be.
Obliged.
Obliged.
Yes.
Lordship, in the last occasion, the respondents said that they would file affidavit in all the petitions.
Where are the respondents? Where is the finance department? Finance.
Lordship, in the last,
Finance.
Lordship, in fact, yesterday, they have filed affidavit in 3 of the petitions. They are yet to file affidavit in the other case.
You want to file a response?
Right.
You want to file a response?
Lordship.
It is sufficient that the respondents have filed some affidavit in the in some of the writ petitions, and in response thereto, the petitioners would like to file rejoinder affidavit. They pray for 3 weeks. Matter stands adjourned for 3 weeks. Yes.
Lordship, in the meantime, if they want to file, they can file affidavits in the other cases because it would be
Respondents
necessary.
are at liberty to file affidavits in all the writ petitions in which they choose. Yes. Where is 11? Passed over. Passed over. None appears for the petitioner, while Mr. Moore appears for additional AG, appears for the respondent. Panchayat Department, Mr. A. Chakraborty,
Respond number 2.
respondent 2. Yes,
The matter will be kept for time being.
sorry,
Kept, the matter will be kept for.
we can't keep it for time being. Matter then the judge for the day. We are releasing it from Pathat. Please inform. We are releasing it from Pathat. Yes.
Obliged.
Well, during the course of time, I will file affidavit. I am ready, madam. I have signed up the deed. And my finance department affidavit is very much required.
You forget about.
We have already
Filing an
completed. We have approved, madam.
You are filing an affidavit.
Today, madam, file.
Mr. Konikor, counsel appearing for Timaha South, submits that an affidavit will be filed today during the course of the day. Taking into record the state submissions made, the matter stands adjourned for weeks, enabling the respondents to file the affidavit and also giving liberty to the petitioner to file rejoinder affidavit if so like.
In this case, the
Finance-
finance department stand is required. They have already approved my proposal.
We have approved my finance.
If they have not filed, they have not filed. We can't help you.
And I am not getting my salary since 2013.
Do you want the affidavit on record or not?
Lordship.
Yes. Mr. Tiwari,
Yes, already. I'm sorry. It came immediately.
That's a that may be fixed. A date may be fixed.
matter be listed after 2 weeks, we have said, we on a date to be fixed by the registry.
Diploid.
You'll have to send your colleague to look for the respondent side because they were here, they are not here now, currently.
Because at least on my side, I'm here.
No, we'd like to complete it. What's
Oh,
the
yes,
point in
that's
keeping
fine,
it
you know.
parted? You can request your colleague.
They got the opportunity to disappear.
Maybe. You can request your colleague to just look for it.
Please find out where they have gone.
Another application that has been registered as WBC number 518 of 2019. This case has been listed on 11/3/2024. before the court number 16.
Whatever it, you want both the matters to be listed
Together.
together. You submitted,
Let,
yes.
I have to say, submit something. Last occasion, court had directed me to produce why his DCRS amount has been not released. As per my instruction, Lordship, DCRS amount, rupees 15 lakhs have been already submitted to the AG Lordship. But whether he has received or not, we have not,
You do one thing,
Lordship.
council wants both the matters to be listed together on 11.
Lordship,
So you make a submission accordingly when the matter is listed.
Lordship, Lordship.
It is fixed on 11.
No, it is the 11 in the court number 16.
Heard learned counsel, Mr. A. Dadgupta, learned senior counsel for the petitioner, and MS
Z Bora, Lordship.
G. Bora, and A. Parasar, appearing for Agriculture Department and Accountant General, respectively, is submitted by the learned counsel for the petitioner that a similar matter listed-
518 of 2019.
is listed on 11, i.e. WPC 511 of
2019.
2019. Accordingly, it is submitted that this matter be also listed for along with the same matter. Accordingly, this matter be listed along with WPC 519, 511,
518,
518 of 2019.
19. Which is in the list in your 11.
Okay.
End of this.
Yes. Yes,
Your Lordship, Senior Counsel, Mr. Pandra is on legs in another court. Your
we'll
Lordship,
pass it over for the day. It's submitted that the counsel for the petitioner is not available. Matter stands adjourned for the day. Mr. Lorenzo appears for the respondent
Lordship, any day may be fixed.
for the day. Yes.
Let me lordship. Okay, kindly see the last two order, my lord. And this is the matter of non-granting the benefit of third MSCP benefit to the petitioner after completion of 30 years service.
Who's for the respondent? CGC.
DGC, even though my lord, the name has also been reflected in the cause list.
What is the matter about?
Matter, my lord, the benefit of third MSCP has not been granted to the petitioner, my lord, after completion of 30 years service by by lacking of the ACR. And that adverse entry of the ACR has not been communicated. to-
CGC.
Otherwise, my lord,
Yes.
otherwise, my lord, this is the covered case, my lord. Kindly see, my lord, the impugn order of the writ petition.
Covered case by which order?
I have the statement of this counter report.
See, the problem is, these are not a part of the pleading. Now, your presence of your counterpart is necessary for that. Where is the respondent counsel? CGC. Call CGC. We'll take it up after a while.
Keep your note.
Yes. Why the councils are not present when the matters are called up? Names are reflected.
On Viberson letter, he was appointed for.
Whoever is appointed has to be there. If they're not there, they're not there.
Yes,
Please bring it to the notice of
yes, my lord.
Deputy Solicitor General.
My lord, he is not, he is in Kohima bench, my lord. Architect. Yes, yes, I'll inform him.
is this, the learned counsel submits that this is a matter which can be disposed of in terms of similar orders passed by court and bench. Please examine and tell us.
Similar order.
We'll call after a while.
My lord, on Monday, my lord, this.
No.
Oh, he is there.
Matters are called up, you are expected to be here when the names are reflected in the cause list.
No, my lord, previous to this, my name is not reflected. Today it is reflected, my lord.
Today it is reflected, but you're not there. That is what
Yes.
we want to tell you.
I'm extremely sorry, my lord.
You tell us whether we can dispose it off, or is there something
No,
else?
my
you want
lord,
to add?
petitioner has made a submission. He has stated in his writ petition that there are certain ACR that has not been communicated to the department. So in that regard, my lord, I need to take an instruction. Just allow me 1 week time, my lord.
After 1 week.
Just 1 week time.
In their affidavit, my lord, they have stated that the affidavit and not, otherwise, my lord, date may be given.
We'll take it up after a while. Wait for some time. Both of you. We'll call up after a while. Yes.
May I please, Lord. Okay, there is
Yes.
a case, my lord, the petitioner, my lord, there's a so-called notice in regard to the, my lord, alleged illegal appointment of, my lord, contractual labor. My lord, on 9/2/2023, so-called notice was issued, which also, my lord, suspension order was issued. Now, thereafter, my lord, the next suspension order extension was issued 24/5/2023. Third is 14/8/2023. Last is 22/11/2020, which term is also expired. Now, despite of that fact, my lord, that the petitioner lady was not allowed to, my lord, resume the service, my lord. As on today, my lord, there is no suspension order on field, my lord. And lordship kindly see 9/2/2023, lordship pass an order to take an attempt for disposal, my lord. Just to point out, my lord.
Who's for the respondent?
My lord, respondent last occasion also, my lord, not present.
Lordship, standing counsel, P. Sharma.
But my lord, yes, not is there, my lord. Not there. Now, lordship, I have filed additional affidavit, bring on record the all suspension order which is on part of record. Lordship kindly see.
What is the stand of the respondent?
You know, they want to say in the affidavit reply, affidavit in opposition that because of that allegation, etc., they have, my lord, drawn out this, my lord, so-called notice and other proceeding, and in their view, my lord, they would like to go further for inquiry, etc., my lord. Now, lordship, the latest development is that, my lord, which I would like to bring to the notice on 20th February 2024, my lord, inquiry officer was appointed. Therefore, my lord, the departmental posting go on, my lord. But so far, the suspension order 22/11/2020, 11, my lord. That time is over in otherwise also, my lord. We will not go to technicalities, my lord.
No, going into technicalities is a different thing, my lord. But here, my lord, what I find, my lord, the projection made in the writ petition is entirely different. And to the projection made in the writ petition, we have responded by filing an affidavit. The suspension order has been reviewed from time to time. Records I have, my lord. Lordship has directed me to produce the record, whether it is reviewed or not. That record I have. Otherwise, my lord, kindly see.
Was it reviewed?
Yes. Yes, my lord, it is reviewed, my lord.
Have you stated in your affidavit?
My lord, in fact, kindly, my lord, if lordship comes to the prayer portion, my lord.
So in your affidavit, have you stated it? Who filed the affidavit?
Nothing is there, my lord.
Well, because
There is no statement here. It was reviewed.
Though I also want to practically, my lord, once this honorable court please to, my lord, peruse the file which they have produced on last occasion. And we have also been directed to, my lord, both to, my lord, there is no such review that has been done. my lord.
no,
Everything we have brought on record by additional affidavit, my lord. Factual aspect.
the records are here. Kindly, my lord, if lordship kindly comes to the writ petition,
What is the stage of the inquiry now?
inquiry officer has been appointed as my learned friend has said, my lord.
When?
On in the month of February, my lord.
February.
Yes.
It is not commenced as yet. Hearings have not commenced.
Hearings are not commenced. Possibly not. Because in February, it has been.
And admittedly, the charge sheet was submitted after 3 months.
Till yet not.
When were you placed under suspension?
My lord, 9/2,
9/2, 24.
Huh?
9/2.
2020.
Where is the order?
My lord, page 88. my lord.
Page 88.
Lordship, please to
My lord,
see my affidavit, my lord, additional affidavit. My lord, I have brought on record the next part of their extension and all information.
no, I have the original record. I can also produce, Lord. I can produce. I'll definitely produce. Well, in the writ petition, my lord, there was no challenge that. In fact, there is no statement that the order has not been, my lord, reviewed from time to time. Therefore, the order is bad. Here, if Lordship kindly comes to para 10, my lord, of the writ petition, the entire projection is there. The authority who has issued the order is not competent to us because it is the projected case that she was at that point of time in a company, and the authority, the who has issued the who has issued the suspension, the order, is not a competent authority to issue the order. That was the challenge. In response to that, we filed the affidavit, and there is no averment in the writ petition. Kindly come to para 11, page 14 of the writ petition. We have responded to whatever he has stated in the writ petition. Page 14, para 11 of the writ petition. Petitioner further urges here that instant show cause notice dated 9/2/23 is not tenable in the eye of law from the point of view of the Companies Act 2013, wherein it is clearly mentioned in section 241 to 246 of the Companies Act that the affected party may take necessary recourse to challenge any misdeeds committed by any officials of the concerned company before Company Law Tribunal, Guwahati, Assam, seeking necessary redressal, but the said aspect of law has been neglected by the respondent number 3 while issuing show cause notice and the suspension order dated 9/2/2023 to the present petitioner, which otherwise requires further consideration by the Honorable Court. Then he said that the petitioner further begs to state that it is also a case of discrimination wherein it is crystal clear that instead of taking any action against the decision makers who were present in the meeting of the board of directors on 28/9/2020, being either the chairman or the directors, the present petitioner has been targeted where she has no role to play, save and except to lead the managerial affairs of the organization as per the direction given to her by the higher authority of the respondent number 2 herein. It is be it reiterated herein that the present petitioner neither took any participation in the decision-making process in regard to such alleged appointments, nor even she has issued any letter of appointment without having the direction passed by the higher authority, that is the chairman, which is discernible from the office record itself. The respondent number 2 is required here to place before the relevant record for kind perusal of this honorable court. But there were large-scale illegal appointments in the AFDC Limited, and because of that, a high-level inquiry was conducted, and in the high-level inquiry, the involvement of the petitioner was along with other officers were found, and accordingly actions were taken. The petitioner is an ACS officer, and the personnel department being the cadre controlling authority.
Where is that report?
Report is not here. It is with the high-level committee report if necessary. If lordship
Produce that report.
I'll definitely produce.
My lord,
I can produce
my
that.
lord, may I point out?
I can produce that. I'll produce that.
Lordship, let me allow to submit. My lord, thing is that, my lord, they are raising certain issues in regard to my lord paragraph, but there is no any counter reply to that effect in their affidavit in opposition. Number one, my lord. Number two, my lord, kindly see whatever allegations, my lord, allegations that would be, my lord, culminated in a way of, my lord, departmental proceeding, they found suitable to go ahead, my lord. For which, my lord, it shows that on 20 February 2024, they have already appointed an inquiry officer. It implies that they would go further for departmental proceeding, my lord. We'll trace it out, my lord. Now, core issue is what, my lord? Core issue is that, my lord, as on today, my lord, kindly see what position they are maintaining, my lord, they are harassing the petitioner, my lord. Kindly see 22/11/2023, my lord, last extension order was passed. Anyway, we'll go for, my lord, 90 exceeding whatever. 22/11/2023 order, my lord, in other way, 22 February 2024 expired, my lord. Now, afterward, my lord, there is suspension order, my lord. Where I am, my lord, as on today. That is the, my lord, a very big crisis. Inquiry officer or inquiry report, whatever, my lord, that will be the part of departmental proceeding. Here, the core issue is that as on today, you are harassing me. You are harassing me, neither you are initiating any departmental proceeding, nor you are supposed carrying out that provision of law by.
Departmental proceeding has been initiated by.
Exactly, ma'am. That's why I'm saying that they will face it on. Allegation is allegation.
Right.
Lordship, kindly see that 22/11/2023, 22/2/2024, my lord. As on today, my lord, afterward, no extension order. As on today, there is no any extension order, my lord.
Extension for?
Father suspension order. Therefore, my lord, where I am, my lord, as on today, Lordship, kindly see. And Lordship, kindly see, if suppose they would reinstate me, what is their harm, my lord? I will face that, my lord.
That is their concern. It's
Exactly,
not
my
for
lord.
us to
That's
say
why, my lord.
whether you should be reinstated or kept under suspension.
My lord, kindly see.
We are here to see whether the suspension is being, order has been issued as per the procedure prescribed.
Quite right, my lord. Kindly see that 9/2023 is the initiation of that suspension order. Now we have raised 2 or 3 issues, my lord, about it. The appointing authority is the honorable governor.
Mr. Nar,
My lord,
when do you propose to proceed and complete with the inquiry?
my lord, as the records were here, that is why there was some delay, but since on second last order, my lord, second last when the matter was taken up, we have taken up and already they have issued the notice and they have proceeded. My lord, I have given the last the in the record, my lord. Kindly see, my lord, that is the review order. The note sheet, it was placed before the honorable chief minister, my lord, and the next page, lordship will find the chief minister's approval, my lord, the honorable chief CM's approval.
Appointing authority is the governor, my lord, honorable governor, and they are, my lord, getting the approval from, my lord, honorable chief minister,
Yes,
my lord,
that is
against the law, my lord.
Yes, that is the
Outright, it is, my lord, violation.
Yes, that is the issue. That is the issue raised in the petition.
That on core issue, my lord, lordship may take a call on that, my lord.
I have the other record. It is a part file. Prior to
When was this review done? 14/11.
with effect from 9/11/24 for 3 months it was done, and the prior to that, this is the file. In fact, since the record was here, that is why they have started that part file.
What does this file contain? What is this original file? This is the file.
This is the file.
File containing what?
The
issue
issuers
for which he was suspended and proceedings are initiated.
Suspension order has been issued in this file. Suspension and the subsequent review order. But from time to time.
Are you getting your subsistence allowance?
My lord?
Are you being paid your subsistence allowance?
Yes.
My lordship, kindly see only one is very important issue
Inquiry
that
report.
22/11/2023 order almost expired.
What is the status of the inquiry today?
But inquiry status notice, the inquiry officer has been appointed. The updated position I will apprise your lordship along with the inquiry report. But I may be allowed to place the inquiry report in a seal cover because it is. I don't want.
Inquiry is completed.
Inquiry is complete. Inquiry on the basis of the high level inquiry committee meeting, they have taken the action.
No. You said some show cause notice was issued. Where is the show cause notice?
My lord,
Show cause notice for the departmental proceeding.
Lordship, that contain in page statement of allegation, etc. Page 82, my lord, start from 9 February 2020. They are sitting silent almost 1 year, my lord.
We are concerned with this inquiry. What is the status of this inquiry? Show cause issued on 9 February. What have you done?
Because of the other inquiry, the records are not with them. That is why some time was taken, my lord. I'll apply.
What other inquiry?
The high level inquiry on the entire affairs. Because there was
You
last time,
submitted that the high level inquiry was conducted pursuant to which she was placed under suspension.
inquiry was there, involvement was found, accordingly action was taken, but the entire materials are not placed. I'll apprise the status of this inquiry, my lord. This is the departmental inquiry they have initiated.
This is precisely what we are concerned with.
Lordship,
My lord, may I place one
You are
document?
placing,
State.
where is the suspension order?
suspension order is
Page 88.
88.
lodged.
This is under 6(1)(a).
Yes, 6(1).
So
Now, in the-
6(1)(a), because of which you have given the show cause notice
yes,
on the same day.
on the same
Suspension and show cause were issued on the same day.
same day.
So what have you done with the inquiry
Well,
for 1 year?
I'll apply. Inquiry officer has been appointed, and what they have done, I'll place it before your lordship.
My lord, the last correspondence
Well,
can see I have placed, my lord.
Eh,
Last, one letter I have given lordship just now. Lordship, this is their present status. Here, my lord, sorry, my lord, that little bit invisible I have brought it from mobile.
You have appointed the inquiry officer after 1 year. Inquiry and presenting officer after 1 year.
Under what circumstances, I'll apply. Look, in the writ petition, nothing has been challenged. That is why in the affidavit.
His only ground is, why have you kept him under suspension for so many years?
No, in fact, my respectful submission is that is not a ground.
Hmm?
Kindly see, para 11, 12, I have read, kindly see 13, para 13. His ground is that this is not a suspension order under 6(1)(a). The authority who has issued the suspension order, he is not the authority. Para 13, kindly see.
Who is the authority?
According to him, he is the governor. He said it is governor only, he can do. Page 15, kindly see, para 13. That is his precise case. That the petitioner further submits that the
It's
state
in the name
suspension.
of the governor only.
My lord,
This is issued in the name of the governor.
my lord, in the name of governor issued, my lord, that is no doubt to that effect, my lord. Question is that, my lord, this is a, my lord, practice they are following. Question is that, my lord, since according, this file nowhere reflect that any point of time, any matter is brought to the notice of the honorable governor, my lord. Now, it is
That
just, my lord, even lordship can see, they have taken the approval from the honorable chief minister, but appointing with his governor, otherwise, my lord, whatever, my lord, ground we have taken, my lord, that is the matter of challenge. The question is that, my lord, the subsequent development is very important. It is in the during the proceeding, my lord, they have appointed inquiry officer, they have extension the all, my lord, the suspension order. But as on today, my lord, 22 February order has been that order has been expired, my lord. Till as on today, there is no any suspension order, my lord. How they can keep me in this position, my lord? Is not it injustice to me, my lord? Outright injustice, my lord, that the order which has been expired in the month of February 2024, nothing, nowhere I am, my lord. It is just a kind of harassment, my lord. Kindly see, my lord, they are alleging that I have, my lord, committed certain allegations of upon, my lord, the political, my lord, person who is, my lord, the chairman, has nowhere, my lord, conducted any inquiry against him, my lord. Just to protect his skin, my lord, I have been targeted, my lord. And I was there just to perform, my lord, job for as a managing director, my lord. The decision-making process is to be adopted by the board of directors, my lord, which is headed by the chairman, which is a political leader, my lord. And he has been, my lord, saved in this entire circumstances. I have been targeted.
No, all these ever arguments that you're making,
Well,
you have to array them as parties.
my lord,
You're making personal allegations
no, my
now.
lord, what I'm saying, my lord, questioning that because I have been found allegations of, my lord, this is another thing.
No,
That is a matter of departmental inquiry.
That is the
That is a matter.
Appointed counsel for the parties.
That is the record.
The government advocate, senior government advocate, Nath, will apprise the court as to the status of the inquiry proceedings initiated against the writ petitioner. ID the show cause notice dated so and so. End of the court. Any review order passed against the petitioner. Review order passed in respect of the suspension of the writ petitioner. Or you say, as to the last review order, reviewing the continuation of suspension of the writ petition. Matter be listed after 1 week.
My lord, can it be, my lord, possible 14, my lord, 14 or 15?
14th of March.
Well, for 14,
15th,
kindly give me in the next week, my lord. I just want to file an affidavit, my lord, bringing on record, please.
no affidavit, you give the input. You are not
Look.
doing anything. You are keeping a man under
But,
suspension and merrily carrying on. What is this?
No,
This is
but
not
because-
how it is to
no,
be
but
conducted.
exactly,
No, my lord, review
In
has been,
spite of so many judgments of the apex court, high court,
no, my lord, review has been done, and my lord says being
My
a
lord,
senior.
I
senior
don't know
SCS
that any
officer-
you are
review is done.
putting a person under suspension pending disciplinary inquiry. You have not proceeded. You just 1 year, you have not appointed inquiry officer,
that,
presenting officer.
that I'll apprise on 15th, my lord. I'll apprise.
You have to give reasons why.
I'll apprise.
Prima facie, it shows that you are using suspension as a punishment. Prima facie.
No, my lord. It's a large scale irregularity committed, my lord.
Then sack the person
Lord,
following the due process of law.
yes, that has to be done. That has to be
Do we need to tell you on each and every case?
done. No, I'll apprise, my lord, what they have.
We'll have to issue directions to the chief secretary
I'll,
that all these cases will have to be personally reviewed by the office of the chief secretary.
I'll see.
List on 15.
Deeply.
Yes.
Yeah, please, Lordship may kindly pass over the matter, Lordship. Senior counsel is on legs.
What is the matter about?
Lordship, petitioner's claim is that he should receive benefits equivalent to that of chief secretary.
Ah. They were supposed to get some information.
Yes, the Lordship. Matter was heard on the last day.
Where is Mr. Borpuzari? Finance. Where is Mr. Borpuzari? Timing.
My lord, status report was called from CGM Kamrum Metro Lordship. Today is the fourth occasion, Lordship.
Yes. Who is appearing for revenue?
The legs under a code, Lordship. They appeared.
Is there only one council? Is there only one council for revenue?
No, Lordship. He has informed me, Lordship. He has informed me that.
Is there only one council?
I understand, Lord.
You are a government council.
Lordship.
We'll hear you.
I have no.
Kindly go through the report.
Not,
There is no charge sheet file. There is no charge sheet file.
I am only appearing, Lordship, Director of Pension, Lordship.
We are directing you to appear for revenue also in the absence of the revenue council. Go through it. We'll record your name. We'll pass orders shortly. Please go to the report called for from the court of the CJM, Kamrup. We'll call it after a while. Yes.
Public.
No passover. No passover. Yes.
You Lordship may pass, kindly pass similar other annexure MPS 55, madam.
File.
Revision of payment is applicable is covered. They have said already, my lord, on 5/1/2024, they have said it is covered.
By
Your
what?
lordship,
By what?
yes, annexure M page 52, my lord.
52.
Similar order may be passed. Only two words are to be changed, my lord. Absolutely, otherwise everything will be same, my lord. Page 52, my lord.
Yes.
Yes, my lord.
Then
Only in case of AP GCL, it will be AP DCL, my lord. In two places, well, otherwise everything will be same, my lord. Nothing is to be changed, my lord.
yes.
In second paragraph, on first line, AP GCL, it will be AP DCL. And in the second, same paragraph,
DCL means
AP,
distribution.
yes, my lord.
Distribution.
Assam Power Distribution Company Limited, my lord. In the same paragraph, my lord, fourth line, my lord.
Yeah.
Again, AEGCL is there. That will be APGCL, my lord. These two or changes are there only, my lord.
Okay.
Second para only these two changes, no, otherwise everything will remain same, my lord. They have already said that it's covered, my lord.
Yes. Heard disposed.
Same order, my lord. Both the cases, my lord. Same.
Mr. Kotoki, you appear for
Yes, he is it.
respondent 3.
My lord,
Name of the council.
based on expert instruction, well, have a area benefits will be paid in the 5 installments.
We don't know. We are disposing it off in terms of the order. You've been given opportunity to apprise the court whether this matter is covered.
Already they have said covered, my lord.
Yes.
Obliged, my lord.
Just
My lord, may I just please, I'm sorry, my lord, I was on legs in a different board. This order perhaps is similar, my lord. Covered case and they, on the basis of the directions passed by the honorable
What
division.
is the difference between the orders enclosed to the writ petition?
Annexure
How is it
M page
different?
52 may be seen. Everything is mentioned there, my lord. The division bench order is also mentioned there.
How is it different?
Yes, my lord.
Yes, ma'am.
Still do, my lord. Deeply obliged.
নাম কেটে রাখি। Yes.
May I please, my lord? I think that case is fairly covered by the previous judgment of this honorable high court. So my lord, may I dispose of the matter?
Okay, heard. Then council is disposed.
Deeply
Okay. Yes, yes.
My lord, here scan copy received, my lord. I will have to go through it, my lord.
Only question, my lord, the lordship I have seen, my lord. After 6 months, he was arrested only because he is the owner of the vehicle, my. Only.
You go through, will be listed. I don't know.
At 2, my lord.
After 2 weeks.
My
No,
lord.
at 2, my lord.
No, no,
Isn't
you
it-
raised
We got the scan copy, how much time required?
Tuesday, my lord, next Tuesday. my lord.
I am not probably available, my lord, because already, my lord, all other persons already got bail, my lord. Let us not 2, my lord, let us take a chance if possible, subject
You
to
see
your
if you can look into it at 2, otherwise
Right.
decide at 2. If you can go through, good,
Fine.
well and good. If you think that you need more time, you inform the court.
My lord. My lord.
Yes, yes, yes. It is part to matter. Yes.
My lord, since it has been a long time, I'll just make a short submission for the benefit of my friends. I'll clarify some of the issues which my lord had raised on the last occasion,
You were
especially
initially appointed in what is that DRDA? No, sorry.
No.
What is that?
I was agriculture extension officer in the irrigation department.
Ah.
From there, I was sent on deputation
To DRDA.
to the panchayat and the rural development department.
Your
So it was from one department to another department, and it was the panchayat and rural development department which had posted me to DRDA Golaghat. So there is a distinction, my lord. From agriculture department, I went to the panchayat and rural development department on deputation. and the Panchayat Rural Development Department
Now,
sent me
they're not allowing your seniority to be counted for the purposes of,
parent department.
for seniority.
Yes. Though the prayer was different, but my Lord, I'm seeking, my prayer is to mold the relief and only to give me the seniority of the parent department in the absorbed post. That is all, because posts are equivalent. Since, my Lord, the sequence of events, it has been a long time, I'll just give the issue back. The list of date, I believe, my Lord, was given earlier. If my Lord
You give
only,
us one more
okay,
list of dates.
very well. Lordship will have a.
Yes.
I'll just go through the dates below. 22/9/94, petitioner was appointed as Agriculture Extension Officer in the Irrigation Department under Regulation 3F. 15/11/97, service of the petitioner was regularized retrospectively with effect from 26/2/96 in the post of Agriculture Extension Officer in the Irrigation Department. 4/2/99, petitioner was sent on deputation in the Panchayat and Rural Development Department to an equivalent post of Agriculture Project Officer Agriculture for a period of 1 year. Lordship may see this initial order, page 46-47 of the paper book.
Yes.
Page 46. Dated 4th February 99, Governor of Assam is pleased to place the services of Sri Safiul Alam, Agriculture Extension Officer of this department, at the disposal of the Panchayat and Rural Development Department as APO Agriculture in DRDA on deputation, initially for a period of 1 year. So that is how it is. Then 25/2/99, petitioner was appointed as Assistant Project Officer, Agriculture in the Panchayat and Rural Development Department on deputation and was posted to DRDA Golaghat against the existing vacancy with effect from the date of taking over charge. 13/3/99, petitioner joined in the post of Assistant Project Officer, Agriculture in the PNRD Department. Then 25/9/2001, communication from Panchayat and Rural Development Department to the Irrigation Department seeking no objection certificate for permanent absorption of the petitioner as Senior Block Development Officer under Panchayat and Rural Development Department. You know, these are all equivalent posts. There is no dispute about that. So NOC they asked for 25/9/2001. 29/9/2001, Irrigation Department gave the NOC to the PNRD Department for absorption of the petitioner as Senior Block Development Officer. Then all of a sudden, there was a change in the situation, and on 27/1/2005, after 4 years, petitioner was repatriated to the Irrigation Department. 23/2/2005, on petitioner moving a writ petition, the Honorable Court by an interim order stayed the repatriation. 23/8/2010, writ petition was disposed of, leaving it open for the petitioner to file application for his regular absorption in the borrowing department. 14/11/2011, petitioner filed an application for his absorption in the borrowing department, that is Panchayat and Rural Development Department. Now, my lord, all throughout he remained here in the PNRD only. There was no break in service as such. Because on the strength of the interim order, he was continuing, and even after the judgment of the High Court, my lord, he continued. Then, my lord, the cabinet memorandum comprising of view or note of the PNRD department and views of Personal and Finance Department respectively, proposing permanent absorption of the petitioner in the PNRD department for approval of the cabinet. Lordship may kindly have a look. Page 68 and 69, Annexure 11.
Yes.
Detailed history is given below. I'll skip it.
What happened to the writ petition earlier? You have disposed of.
The writ petition was disposed of, leaving it open because court said you don't have a right. Very true, that is a legal position. One cannot demand absorption as such. So court said you don't have a right, but it is for the department. You make an application, they will consider it. So this is what it was all about. That is annexure 9, page 64, 65. I'll read the operative portion. Page 64 and 65.
Yes.
Page 65, the first subpara.
65.
Page 65.
Yes.
As a deputationist, the petitioner has got only a limited right. Irrespective of any policy decision, he cannot claim that having continued for few years, he must be absorbed in the borrowing department. That's the legal position, my lord, no difficulty about that. Such and such has produced a copy of the order dated such and such, in which under similar circumstances and noticing the aforesaid office memorandum dated 16/7/97, it has been held that a deputationist cannot continue in the borrowing department, and that on the strength of the said office memorandum also cannot claim absorption in the borrowing department. However, it was provided in the order that it will be open for the petitioner to file application for regular absorption in the borrowing department. Considering the matter in its entirety, this petition is disposed of in terms of the said order dated 2/5/2007, passed in WPC such and such, interim order passed on such and such, stands vacated. That's it, my lord. This was it. So, my lord, I continued. I filed an application in terms of the order of this honorable court, and then there is a cabinet memorandum for a cabinet decision. The detailed history of the case is given. I'll skip that. Then 27th of July 2016, cabinet meeting was held, and the proposal for permanent absorption of the petitioner in the establishment of the Commissioner PNRD department was approved. My lord will see the approval. Page 71. That is pursuant to cabinet decision. Page 71, Annexure 12. Permanent absorption of services of Shri Safiul Alam, Assistant Project Officer, agree, DRDA, such as such, Nagaon, under the establishment of the Commissioner, Panchayat and Rural Development Department.
Page number?
Page number 71. Approved. Permanent absorption of services of such and such, Assistant Project Officer, Nagaon, under the establishment of the Commissioner, Panchayat and Rural Development. So, the proposal for permanent absorption approved. Pursuant to this cabinet approval, my lord, the notification was issued by the Additional Chief Secretary, passing an order. That is dated 12/9/2016, Annexure 14, page 78. This I read, my lord, page 78. On his services being placed at the disposal of Panchayat and Rural Development Department by the Irrigation Department, Government of Assam, such and such Assistant Project Officer, Nagaon, is hereby permanently absorbed against the vacant sanction post of Deputy Director Training, which was created wide number such and such 22/357 and retained permanently wide number such and such. So post was created in 57, retained permanently such and such under the establishment of the Commissioner, Panchayat and Rural Development Assam, with effect from the date of joining in Panchayat and Rural Development Department. Herein lies a catch. The last line says, the absorption is with effect from date of joining in Panchayat and Rural Development Department. Now, the date of joining, whether the date of joining would be joining as a on deputation or whether joining pursuant to the order of absorption.
Cabinet, does it reflect anything on
No,
past
doesn't.
services? Nothing.
Absolutely silent. Cabinet kept quiet, and my lord, the notification is of this nature. With effect from the date of joining in the Panchayat and Rural Development Department. So, my lord, the tug of war started. What is the meaning of the date of joining? Joining as what? Joining as on deputation or joining after the absorption to the post of Deputy Director Training? The petitioner said, well, you never told me that my earlier seniority will not be counted. That if my joining is after the absorption, if that is to be counted for seniority, I will lose everything. The entire service is wiped out practically with the government of Assam. Because ultimately I was born I started serving with the government of Assam. The deputation was from one department to another department within the government of Assam. So all those issues came up. So, my lord, correspondence started between the departments. So far as I am concerned, my lord, after the order of absorption, on 1st October 2016, I took over the charge. 1/10/2016, petitioner took over the charge of Deputy Director Training.
Yes.
That is the date. So far as, my lord, my regularization as government employee with the government of Assam is concerned, it is with effect from 26/2/96. So what we are looking at is complete wiping out of the service with the government of Assam effectively from 26/2/96 till he takes over charge of Deputy Director Training on 1/10/2016. So practically, we not 20 years. If what government of Assam has chosen to do ultimately, if that becomes final, the result will be the service of 20 years will get wiped out. So, my lord, on 22nd February 2017, the query was raised by the Office of the Accountant General Assam on petitioner's date of absorption as Deputy Director Training. Lordship may see this letter, the query, at page 79 to 81.
Yes.
Page 79, my lord, it starts.
Yes.
In inviting a reference to the government notification dated 12/9/16 and a representation submitted by Sri Safiul Alam, Deputy Director Training dated 4/10/2016 on the subject noted above, I am to state that as per government notification mentioned above, Sri Alam has been permanently absorbed against the vacant post of Deputy Director Training in the scale of pay of rupees such and such, 4-grade pay, such and such, with effect from the date of joining in the Panchayat and Rural Development Department, in pursuance of which Sri Alam took over the charge of Deputy Director Training on 1st of October 2016. Accordingly, pay slip number such and such has been issued. Whereas Sri Alam, by his representation, has stated that he has been permanently absorbed as Deputy Director Training with effect from 13/3/99, i.e. the date on which officer services have been placed under PNRD department by the Irrigation Department. In view of this, government is requested to let this office know the exact date from which Sri Alam has been absorbed permanently as Deputy Director Training under PNRD department. In the event of the absorption with effect from 13/3/99, the following points require clarification. 1. The scale of pay to which the officer has been absorbed and the date from which the post is lying vacant. The scale of pay to which the officer has been absorbed and the date from which the post is lying vacant. 2. What would be the treatment of the amount of leave, salary, contribution paid such as the whole period. 3. The name of the officers holding the post of Deputy Director Training in the PNRD department with their tenure of office with effect from 13/3/99. Because the query was ultimately in the post of Deputy Director Training if anyone was working earlier during that period. Because if the whole idea is that my seniority should be shown against the post of Deputy Director, then the question would be as to whether the post was vacant at all prior to that. So these queries were raised. And the answer came, the query was forwarded, I will skip that. Then the reply comes. The reply of the Commissioner PNRD Department on the post of Deputy Director Training. The reply is dated 6/4/2017. Annexure 17, page 85.
Yes.
Page 85 is from Commissioner Panchayat and Rural Development Department to Secretary to the Government of Assam. With reference to the subject cited above, I am to furnish the report related to point number 3 contained in the letter number such and such. The name of officer holding the post of Deputy Director Training under the establishment of Commissionerate, Panchayat and Rural Development Assam with effect from 13/3/99 till 30/9/2016 may kindly be treated as nil as the earlier incumbent, namely such and such, the then Deputy Director Training retired on 28/2/99 from his service, and since then the post of Deputy Director Training was lying vacant in this commissionerate. So, my lord, the post was lying vacant effectively from March 99. Nobody was holding this post. It was vacant all throughout. This is the reply.
There were three queries raised.
Yes.
Reply is only with regard to number 3.
Other two queries were answered in the next page, page 86. The required information, page 86.
Yes.
I am directed to furnish here with the required information as sought for pertaining to the matter of permanent absorption of such and such against the such and such, against the post of such and such. 1. In the scale of pay of rupees 12,000 to 40,000, pay band 4 with GP 6,300. The post was lying vacant from 1,399. Leave salary and pension contribution made during the deputation period are mandatory and are to be adjusted. 3. The post of deputy director training has been lying vacant with effect from 1,399. Hence, furnishing of the name of officer holding the post doesn't arise. So this is it. Now, my lord, so far as I am concerned, my lord, my submission would only be when I join as deputy director training, effectively I am getting salary from that very particular date. All right. But so far as my past services are concerned, both during the deputation period as well as in the parent department, in the equivalent post, count that only for the purpose of seniority. I am not seeking give me salary, give me wages of that period. Sorry. So, my lord, I am not demanding back wages, etc., etc. I only said only for the purpose of seniority. You count that period.
What does the rule say?
I'll come to that. I'll come to that. Rules are, first of all, my lord, that is by the cabinet decision. There is no rule regarding absorption. Number 2, there is no rule on fixation of seniority after absorption. The rules are not there in respect of any of the two things. Then what do we do in a situation of this nature? On this, I will address my lord. So, my lord, this is the position. So, reply came, and then thereafter, initially, then, my lord, 1 or 2 documents more I will show. Then, 26th of July 2017, more clarifications sought for by the Accountant General's Office from the PNRD department. 16/8/2017. Representation of the petitioner such and such, such and such. There is only thing page 85 that I have shown already. Finally, my lord, the stand was reversed. That is by annexure 20, page 1991. That is the UO note of Joint Secretary PNRD department opining that the petitioner's date of adoption will be the date of joining as Deputy Director Training in PNRD department. That is 1/10/2016. And endorsing the matter to Personnel B department for their view on the matter pertaining to such and such. So, my lord, annexure 20, page 1991 is impugned.
Yes.
And then 28/8/2020, the last date, page 115.
Yes.
The letter of Principal Secretary to the Government of Assam PNRD Department to the Accountant General Assam is stating that the effective date of absorption of the petitioner should be treated to be 1/10/2016, the date on which he took charge to the post of Deputy Director Training in the PNRD Department. So, practically, it is this stated position by which we are aggrieved that why are you treating the date of joining, that is 1/10/2016, as a date from which my seniority will be counted. Why the earlier period is being wiped out? That is the only issue for the consideration of your lordship. Now, my lord, some of the things are undisputed. Namely, it is not disputed that the post of Agriculture Extension Officer in the Irrigation Department is equivalent to the post of Deputy Director Training in the PNRD department. That no one is disputing that position. The only issue is when the rules are silent. So far as absorption is concerned, that was by cabinet decision because rules were not there. Now, rules are also silent as to what do you do when after absorption your seniority is to be fixed, whether past services should be counted or not. In many other cases before the Supreme Court, the rules were there.
These past services, you want to be counted for what purpose?
For the purpose of seniority, naturally, not because there should be continuation of service. Otherwise, what happens? When I retire, my lord, there are two things.
Is there must be a gradation list in the post of deputy director?
Deputy director, my lord, has seen the position since March 99, the post was lying vacant.
Only one post.
Yes, but the
There-
post was vacant from March 99.
Saying in the cadre of deputy director, is there
Yes.
only one post?
Yes, this is what I understand. This is the impression that has been given to me. The post is only one. And this was vacant.
And
So
what
now,
is
my
the
lord, what is the legal
next-
position?
What is the next promotion? Director.
It should be joint director, director thereafter, obviously. That is why these issues will come up. And first of all, my lord, what happens? If the past services are not counted, then effectively, my lord, my service begins with as on October 2016.
No, see, there are, as I understand, there are two compartments. One is what you are arguing, that past services for seniority pension must be granted. There could be another proposition that past services for pension will have to be given. They cannot be, otherwise it will amount to a break-in service.
Yes.
Past services for seniority will depend on so many other aspects.
I'll deal with this.
including
I'll deal
how
with
many
both the
posts,
compartments.
What is the cadre strength?
My lord, my submissions are going to be like this. First of all, there has to be continuation of service for the purpose of pensionable period. That's one aspect of the matter. So far as this aspect of the matter, nobody should have any difficulty about it. So the continuity in service is protected and safeguarded. That's one part. Now, after this part, the second issue arises, namely, as to whether or not the past services in an equivalent post in the parent department should be counted for the purpose of fixation of seniority in the cadre of deputy director training. Because if this seniority is counted in the cadre of deputy director training, then in that eventuality, obviously, my lord, for the purpose of further promotions, because ultimately, my lord, though merit is always a factor, I understand the post higher than this would be a selection post. Merit is the primary consideration, but seniority always matters. There are other equivalent posts also. So now, my lord, the issue would be as to what do we do in a situation where the rules are silent on the fixation of seniority. What is the legal position? Because service law is the judges' made law. How judges have dealt with this very kind of a situation. So, my lord, I have referred to S.I. Ruplal.
I would like to rephrase. It's a judges made law, but on the arguments made by lawyers at the bar.
Arguments from both the sides, certainly, and obviously, my lord, it's both ways.
Yes.
Otherwise, that is how, my lord, the cohesive and complete
how it
picture
has to be.
emerges.
Absolutely.
So that is how. So now, my lord, on the last occasion, I had referred to S.I. Ruplal, laying down the principle. Now,
What is the citation?
I'll come to that. Well, I'll deal with all these judgments. When I refer to S.I. Ruplal, my lord, as a counter, they brought in Indu Bhushan. In the Bhushan case, then there was a conflict between the two judgments because Lordship noted that Indu Bhushan had referred to S.I. Ruplal and distinguished S.I. Ruplal. Then I went into other aspects, other judgments. So today, my lord, what I have done is, I have prepared a small write-up referring to all these judgments with the principles. Now I'll come to the, my lord, my write-up on this aspect. I'll read this first. Please, have a copy. This is my write-up. I'm not referring a judgment. Thereafter, my lord, I'll come to other judgments. I'll just explain everything. The two cases, my lord, I'm referring to, I read the entire judgment, I pulled out the ratio, the distinguishing aspects, and the noteworthy features. And how do we, my lord, make our way? Now, S.I. Ruplal, my lord, I'll just present it. In this case, appellants were sub-inspectors of Border Security Force and were taken on deputation in Delhi Police as sub-inspector executive in terms of Rule 5H of Delhi Police Appointment and Recruitment Rules 1980. Pausing here, let me clarify. From BSF, appellants come to Delhi Police as sub-inspector executive. their deputation, my lord, was in terms of the rule. There was a rule even for deputation. So in terms of Rule 5F of Delhi Police Appointment and Recruitment Rules 1980, which provided for transfer and deputation. In the present case, it seems, my lord, even for deputation, they had no rule. It seems so. No rule was referred, which provided for transfer and deputation. Subsequently, the appellants were absorbed in Delhi Police in the same capacity in terms of Rule 17 of the above rules. So, my lord, even for absorption, there was a rule in SI Rupla. Rule 17 empowered the Commissioner of Police Delhi to sanction permanent absorption of persons sent on deputation. So, my lord, over here, since there was no rule for absorption, a cabinet decision was necessary. 2. While fixing their seniority in Delhi Police, service already rendered by them as sub-inspector in BSF was not taken into consideration on 2 grounds. Firstly, the pay scale of sub-inspector in BSF was not equivalent to pay scale in Delhi Police. And secondly, the office memorandum dated 29/5/86 excludes the appellants from getting such benefits. The Central Administrative Tribunal affirmed the decision of Delhi Police of not taking into consideration the past services rendered by the appellants in BSF for fixation of their seniority in Delhi Police on both the aforesaid grounds, namely, pay scales were not similar, and number 2, the office memorandum of 29/5/86 excludes the appellant from getting such benefit. That said, on both the grounds, you are not entitled to. It was held by the Honorable Supreme Court that the right of the appellant to get their past services in an equivalent post of the parent department counted for fixation of their seniority in the borrowing department could not be taken away in the garb of the office memorandum. It was also held by the court that any rule, regulation, or executive instruction which has the effect of taking away the service rendered by a deputationist in an equivalent cadre in the parent department while counting his seniority in the borrowing department would be violative of Article 14 and 16 of the Constitution and thus liable to be struck down. Para 19, 20, and 23. Then, my lord, while discussing the equivalence of 2 posts for counting of the past services, it was held by the Supreme Court that equivalency of 2 posts is not judged by the sole fact of equal pay, and that while determining the equation of 2 posts, many factors other than pay will have to be taken into consideration, like the nature of duties, responsibilities, minimum qualification, etc. In this context, the Supreme Court placed reliance on its 1968 judgment in the case of Union of India versus P.K. Roy, 68 Supreme Court 850, wherein the court had laid down 4 facts for considering the equivalency of posts, namely, 1, the nature and duties of a post, the responsibilities and powers exercised by the officer holding a post, 3, the minimum qualification, if any, prescribed for recruitment to the post, and 4, the salary of the post. It was further held by the court that if the earlier 3 criteria mentioned above are fulfilled, then the fact that the salaries of the 2 posts are different would not in any way make the post not equivalent. Para 17. So, my lord, equivalence so far as salary is concerned was not a determining feature. The host of factors have to be taken into consideration. That was the principle. While taking the above view, the Supreme Court noted that the law in regard to the right of a deputationist to count his service for the purpose of seniority in the transfer department was settled as far back as in the year 82 in the case of R.S. Makashi and Wing Commander J. Kumar. Both the citations I have given. And it is reasonable to expect that a deputationist, when his service is sought to be absorbed in the transfer department, would certainly have expected that his seniority in the parent department would be counted. Para 19. So now, my lord, the submissions I am making on the basis of this very judgment. 1. In S.I. Ruplal case, there was no seniority rule, and seniority was thought to be determined by way of an executive order issued on the basis of an office memorandum dated 29/5/86. Actually, my lord, it was an office memorandum, an executive order was issued pursuant to that.
In Hindu Shekhar, there was a rule.
I'll come to that. Yes, there was. I'll come to that. So, my lord, it was by an executive order issued on the basis of an office memorandum, 29/5/86. So, my lord, the important part is in S.I. Ruplal, there was a rule for absorption There was rule for bringing the person on deputation, but there was no rule for fixation of seniority on absorption, which was done by way of an executive order on the strength of an office memorandum, which was never made public. So, that was not made public also. It was another aspect. And as such, its existence was not known to the appellants. The Supreme Court declared in paragraph 23, quote, any rule, regulation or executive instruction which has the effect of taking away the service rendered by a deputationist in an equivalent cadre in the parent department while counting his seniority in the deputed post would be violative of Article 14 and 16 of the Constitution, hence liable to be struck down, unquote. However, in the same paragraph, it was also noticed by the Supreme Court that office memorandum in its entirety does not take away the right of the deputationist, and by striking down the offending part of the office memorandum, the right of the appellants could be preserved. Therefore, the Supreme Court acted accordingly. So, my lord, there were two things. Number one, the office memorandum was never brought to the notice of the appellants. They were not aware of the fact that this office memorandum and the executive order issued on the basis thereof prohibited fixation of such a seniority. They were not aware of it. But the court said whether you are aware or not aware makes no difference. Such an office memorandum cannot exist because you have a right of seniority. And there was no rule for seniority in Asai Ruplal. In Asai Ruplal case, the Supreme Court, while noticing its earlier judgment in R.S. Makashi and also para 23, again I have referred. This is it. Now I come to Iddu Shekhar. 2006, 8 SAC 129. Facts. In this case, the private respondents, while serving in UP Jal Nigam, were sent on deputation to the Ghaziabad Development Authority on different dates. Not pausing here, I clarify, the status of UP Jal Nigam and Ghaziabad Development Authority were totally different. Two different entities completely. So they were sent on deputation on different dates. By an Amendment Act of 1985, the state of Uttar Pradesh inserted section 5 capital A in the UP Urban Planning and Development Act 1973, creating development authorities centralized service, a common service for all the development authorities, which included Ghaziabad Development Authority. Subsection 2 of section 5A prescribed that upon creation of a centralized service, a person who was serving not on deputation, on the post included in the service of a development authority before the creation of common service shall, unless he opts otherwise, be absorbed in such service. Finally, if he was already confirmed in his post, and B, provisionally, if he was holding temporary or officiating appointment. Admittedly, the private respondents were not covered by section 5 capital A subsection 2 of the 85 Amendment Act, because number one, my lord, they were not serving with the development authority, and number two, my lord, they had come on deputation. So both the requirements, my lord, the private respondents were not able to fulfill. Then what happens? The UP Jal Nigam was not a development authority, and as such, its employees sent on deputation to the development authorities could not be absorbed in the centralized services in terms of subsection 2 of section 5A. Be that as it may, the private respondents were given the option. So again, a very important part, my lord, of Iddu Shekhar saying, here the doctrine of election comes in, because the private respondents were given the option of absorption in the authorized centralized service subject to certain conditions, one of which being that his past service in the UP Jal Nigam would not be counted towards their seniority in the centralized service, and they would be placed below the officers who were appointed on regular basis in centralized service. So, my lord, the option was given, and the private respondent accepted the offer and resigned from their service in the UP Jal Nigam and were placed below the appellant in terms of Rule 7 of the UP Development Authorities Rules 1985. My lord, pausing here, my lord, I submit. Certainly, my lord, in the present case, this did not happen. If they really, once, my lord, they decided that they will absorb me pursuant to my application, they could have given me the option also. They could have told me, we will absorb you, fine, but look, this is the condition. If you are willing, accept it. If you are not willing, you go back. My lord knows very well, if I am repatriated, I get my seniority over there in the parent department. No such option was given to me. The order of absorption came in pursuant to a cabinet decision with effect of the date of joining in the PRD department. So being agreed by the placement below the appellants, the private respondent approached the High Court in a writ for a relief that they be given benefit of past service rendered by them in their parent department, that is UP Jal Nigam. The High Court, on the basis of Sub-Inspector Ruplal case 2001 SEC 644, allowed the writ petition. Supreme Court reversed the judgment of the High Court, holding that the ratio of SI Ruplal case could not be followed in the case. So, my lord, the reasons for which Supreme Court did not follow the SI Ruplal principle in the Indu Bhushan case were as under. This I am reading, these reasons are as under. 1. Section 5A2 of the UP Urban Planning and Development Act 1973, as amended in 85, had expressly excluded two categories from absorption. First, those employees whose parent employer was not any of the development authorities. Second, those employees who were serving on deputation. So, in any case, pursuant to the rule, my lord, they were not entitled for any absorption. 2. Since UP Jal Nigam, parent employer of the private respondent, was not a development authority and the private respondents were deputationists, on both counts, they were excluded by law from the benefit of absorption. 3. In spite of the mandate of law to the contrary, the state exercising its residuary powers gave the option to the private respondents as to whether they want to be absorbed in an authorized common centralized service subject to their accepting certain conditions. One of which was that their past services rendered in the UP Jal Nigam would not be reckoned for the purpose of determination of seniority, and they would be placed below the officers who were appointed on regular basis in centralized service after their absorption. Private respondent accepted the offer of the state and resigned from their service in UP Jal Nigam, resulting in their absorption. Hence, by doctrine of election, they were prohibited from claiming seniority over the appellant because you accepted it with open eyes. Rule 7, Sub-Rule 1 of the UP Development Authority Centralized Service Rules provided for counting of past services of absorbed employees rendered in Development Authority. And in terms of this rule, the appellants were placed above the private respondent. After absorption, the seniority of the private respondents was determined in terms of Rule 7, Sub-Rule 1 of the 1985 rules, and they were placed below the appellants in seniority. Both in S.I. Ruplal as well as in Indu Shekhar Singh, there was a rule for absorption. And lastly, no rule for seniority in S.I. Ruplal in the event of absorption. In Indu Shekhar Singh, there was a rule for seniority on absorption. But not so far as the appearance in Indu Bhushan are concerned, even though there was a rule for absorption and there was a rule for seniority, they were prohibited. But the option was given to them, they accepted the option. So doctrine of election came in, Supreme Court said, no, SI Ruplal ratio will not be followed. You are not entitled to count your past services, so far as Indu Bhushan is concerned. So clearly, Indu Bhushan can be easily distinguishable. And the ratio of SI Ruplal cannot be transplanted in the case of Indu Bhushan. Now, the features in the present case, I have culled out.
And vice versa.
Yes, either way. Now, the present case, I have culled out the significant features. 1. Petitioner held the regular post of Agriculture Extension Officer in substantive capacity in the Irrigation Department since 26 February 96. He was sent on deputation on 4th February 99 to the Panchayat and Rural Development Department, and on 25 to 99 was appointed as Assistant Project Officer Agriculture and was posted to DRDA Golaghat against the existing vacancy. 3. The post of Agriculture Extension Officer in Irrigation Department is equivalent to the post of Assistant Project Officer in Panchayat and Rural Development Departments. 4. Since service rules were silent on absorption by a cabinet decision dated 27 July 2016, the absorption of the petitioner in the establishment of the commissioner.
What is your status? You have retired now.
No, but I am working.
You're still working.
Oh, yes.
Still working.
Substantial years are left.
In which post?
Deputy Director Training.
Deputy Director.
Yes, obviously, this is the post. The absorption of the petitioner in the establishment of the Commissioner PNID Department was approved. The notification dated 12/9/2016 was issued with the approval of the Cabinet in exercise the power of relaxation of rules under Rule 26 of the Assam Panchayat and Rural Development Officer Service Rules 2013, absorbing the petitioner to the post of Deputy Director Training with effect from the date of joining in the Panchayat and Rural Development Department. On 1/10/2016, the petitioner took over charge of Deputy Director Training. In response to the query dated 22nd of February 2017, raised by the Office of the Accountant General, the Commissioner PNRD Department replied that the post of Deputy Director Training was lying vacant since 1/3/99, and as such, absorption of the petitioners as Deputy Director Training was with effect from 13/3/99 in the PNRD Department. So, my lord, even if it is 13/3/99, I have no difficulty with that. Though, my lord, legally, I would like to submit that the date I began my service as Agriculture Extension Officer in the regular capacity, the entire period is to be counted. But since petitioner himself submitted, that fine, let it be from 13/3/99, the date on which the post became vacant of Deputy Director Training, it will suffice the purpose. But not till 13/3/99.
It is your argument.
My legal, because my
It is
argument
your
has to be
argument
legal.
that these posts are equivalent.
Equivalent. And no one is disputing that position. Because otherwise, he would have been benefited once he was sent on deputation.
You were initially deputed to which post? Extension officer.
The post is this is called
Project
assistant,
officer.
yes, project officer.
Project
Uh,
officer. Now,
From
project
irrigation
officer
department.
and deputy director training are equivalent.
Yes, equivalent. Again, equivalent. Equivalent post. There may be slight variation in the payment and all that, but the posts are equal. And thus, that position is not being disputed. So, my lord, the most important part another is, here is not a case that the person has come from outside the government of Assam to the government of Assam. Here is a case of being sent on deputation from one department of the government of Assam to another department of the government of Assam. The principal employer remains the government of Assam. There is no change so far as the principal employer is concerned. So, my lord, on these facts, as to whether or not the petitioner is entitled to be given the seniority of the post held by him in the parent department is the question for the consideration of a law. Now, my lord, Indubhushan is not the end of the matter. Even after Indubhushan, my lord, there were a series of cases. I will refer to my lord Mrigank Johri 2017 8 SEC, but before I do that, please. Before I do that, I'll just take your lordship to some of the relevant paragraph beginning from R.S. Makashi to R.S. Makashi's case and coming to Joginder Kumar, which has been referred to repeatedly by the Supreme Court in a series of cases. How the concept came into being. R.S. Makashi is 82-1 SEC. 82-1 SEC, page 379. I will only refer to one paragraph, paragraph 36. What the Supreme Court says.
This is for what proposition?
The wholesome principle of counting of seniority.
In the past services.
Yes.
In equivalent post.
Because it all came from Makashi, the principle. Para 36 in Makashi case, R.S. Makashi 82-1 SEC 379.
Airport.
Para 36 I just read.
It's that Air Force case.
R.S. Makashi, yes. No, Joginder Kumar, I think, my lord, was Air Force.
Anyway,
this is the case from the state of Bombay, CFD.
Yes.
CFD department, controller of food grains distribution. Joginder Kumar, I think, was. So, para 36 is relevant. What Supreme Court says, there is the wholesome principle. Para 36 at page 405, the last 6 lines.
Yes.
Last 6-7 lines in para 36, it is a just and wholesome principle commonly applied in such situations where persons from other departments are drafted to serve on deputation. Their interest seniority in the parent department should be respected.
Have you supplied any copies?
My lord, Makashi, I'm sorry, I have not supplied. R.S. Makashi, I have not supplied. Lord, may see mine, my lord, last 7 lines, para 36. I'll read slowly, my lord, for my lord's benefit. Lordship may have a look. I have marked it.
Print out later. You should give a list of books so that
very well.
follow with you.
Very well. So it's RS Makashi, my lord, 82 1 SCC 379, para 36.
Does it-
Or my lord, I will not read out, I will just give the citations and that's all.
It are meant to be read out
Very good.
and to be understood
Because nothing much is left, my lord, only
while
the
we are at the
citations.
job.
Very good,
Instead
very
of
good,
leaving
very,
it
very good, very,
for
very good.
absorption later.
Oh. Or, please, thank you. Because Makashi, my lord, the Supreme Court spoke about respecting the interest seniority in the parent department. And from there, my lord, the principle was developed further in the Joginder Kumar and taken to yet another stage in Madhavan and S.I. Rupla. S.I. in the Bhushan is slightly on a different track. But again, the principle was reiterated in Ragang Johri, which is 2017 8 SCC 256.
No, but you had given the list of books.
I'm sorry. That's my fault. That's my fault. Kindly. 82 1
You give a list. देखो अब किताब मिलता है.
So 82 My lord, may kindly have a look at Makashi. Here the rule, my lord, prohibited that respecting the seniority in the parent department. So the court said no, seniority in the parent department has to be respected when the person goes on deputation. That's a fundamental principle. And this principle, as what Supreme Court called the wholesome principle, was taken to a next level, reiterating this position. Because if you respect the seniority in the parent department, then the consequences follow once you are absorbed. Because my lord, in S.I. Ruplal, this progression of law on the subject was discussed, beginning with Makashi.
You're referring to para
36.
36.
The just and wholesome principle. In the light of Article 40.
But is it a case where they're permanently absorbed?
No, my lord, I'm discussing the evolution of the principle. Evolution of the principle. How the principle evolved.
No, definitely, for a deputationist who has gone out,
Yes.
seniority will have to be preserved in the
Yes,
parent
so
department.
then, my lord, then in that case, I need not refer to other judgments. I will refer to only one. Mrigank Johri, 2017, 8 SEC. Only one. 2017, 8 SEC. Only one I will refer. This being the latest. Again, my lord, facts will be different in every case. But
Give the citation, please.
Mrigank Johri is 2017, 8 SEC 256. 2017, 8 SEC 256.
Yes,
Because in service matters, my lord, facts would never be similar, my lord, would always be different. It is no doubt true, para 31 at page 269. It is no doubt true that the OM dated 29/5/86, as modified by OM dated 27/3/2001, did provide for the benefit of the previous service rendered in the cadre. This is in effect also the ratio of the judgment in Sub-Inspector Ruplal case. This would also be in conformity with the normal service jurisprudential view. So, below, leaving aside even the memorandum, what the court says, in conformity with the normal service jurisprudential view. However, it would be different position if the absorbing department clearly stipulates a condition of giving willingness to sacrifice the seniority while preserving all other benefits for the absorbee, which are accepted, failing which the option was available to the absorbee to get himself repatriated to the parent department. The terms and conditions are categorical in their wording that the absorbee would be deemed to be new recruits and the previous service would be counted for all purposes except his or her seniority in the cadre. The appellant accepted this with open eyes and never even challenged the same. The Lord's situation is very similar to Hindu Bhushan, doctrine of election. So, I am referring to this Mrigank Johri for two reasons. Number one, here is the case. Ruplal again was referred. And number two, to show as to how I stand very, very different than the position that emerges over here. Because here is the case, cabinet takes a decision of absorbing me. Apparently, my lord, the petitioner does not know that when he will be absorbed, his past services will not be counted. So, my lord, the question of the application of doctrine of election did not arise in the present case. My lord, had the government of Assam told me, look here, we are absorbing you, but tell us, we are not going to give you your seniority. Your services will be counted from this date. I could have gone, my lord, back. Para 31. So therefore, my lord, I say, Article 14 comes into play, the normal jurisprudential principle will come into play, the just and the wholesome principle will come into play. Government of Assam is my father. The father cannot put child in a distress, that too of such a severe nature. And here is not a case that leaving one father, I came to another father. That my parent was different and my adopted father is different. I am not an adopted child. The father remained one.
What was the issue here in this petition? Mrigank.
Mrigank, again, not similar to Hindu Bhushan. Similar to Hindu Bhushan. Factually. I am referring to this only for that purpose because I have gone through more than 10 judgments and I have found that each fact will be different in every case.
The whole problem was that in the cabinet memorandum, there was no issue about seniority.
Precisely.
It ought to have been there.
Now, my lord, belatedly it can't be done. Now we cannot call upon the government of Assam to have a rethink over the matter. Today, if the government of Assam says nothing doing, you go back. Because I have been told, my lord, that his contemporaries in the irrigation department, they are all directors. Obviously, they will be director. So that's the difficulty that has arisen. Here is not a case that doctrine of election was applied. That option was given to me. I exercised the option. Nothing was made clear to me. Yes, it's true. I was interested in absorption. Because the person who serves for so many years would like to be absorbed. But while absorbing me, there was no clarity. And date of joining initially was interpreted differently. The hope was always there. So petitioner said, if that be the case, the vacancy in this was for March 99. You count from that period. That will suffice for the purpose. So, my lord, my submission finally would be,
Yes.
I would urge my lord to consider applying the just and the wholesome principle of counting the past services rendered in the parent department for the purpose of determination of seniority in the department where he was absorbed. That's my submission finally. That's all, my lord. My lord, I am waiving my right of reply. Whatever my learned friend, my lord, is going to submit, my lord, is welcome. And because nothing more I can add into all this. So, my lord, that's all, my lord. I am highly obliged for patient hearing. And I am waiving my right of reply, my lord. I am making it clear.
You're waiving.
I am waiving, my lord. I have nothing. Unless and until there is an important clarification, my lord. Because, my lord, I will always
thought you
submit
had
before my
served
lord.
your right.
My lord, I am waiving my right, but I am always subjected to the decision of my lord. Because my right cannot be above the rights of my lord of asking questions to me. Because my lord has to adjudicate the matter. If my lord, I might waive,
No,
but my lord may
but-
feel.
No. But over and above that, let me tell you that in spite of asking queries and giving replies, you still have a right of reply if you want.
Certainly,
Unless you
my lord,
waive.
but my lord, if my lord has some clarifications, I will
Yes.
submit before my lord. Otherwise, my lord, I would like to be relieved of this case because at least I'm extremely lucky that today all my esteemed colleagues are present because one way or the other, my lord, case was getting deferred. So that's it.
That deferment was not on account of the court.
Certainly, my lord is always here. My lord is always here. The problem is with us.
Anyway, yes.
So, my lord, my only difficulty today, there is another parted matter in a different court.
No, please.
So once I begin, my lord, the rest of the time will go
We are
there.
surprised that you have spent so much of time
No,
here.
my lord, I'm grateful to my lord for patient hearing, and my lord, if there is any doubt, my lord, I am always here.
We'll
my
trouble
lord.
you again.
Sure, my lord.
Yes. Thank you. Yes, EG. He's only agreed with his seniority. That's all he wants.
Yes, your lordship. Your lordship, the core question is here is your lordship whether he is holding a post of equivalent rank or not. That is. But before that, your lordship, I would like to place some facts before your lordship. Your lordship, may turn to page number 46. Your lordship.
What about the fundamental rules with regard to claim of past service?
Your lordship, also clear apart from 14. Lordship, FR 14 and so far as seniority is concerned, your lordship, I have not found anything in the FR. But here, your lordship, they may kindly turn to the page number 46, Annex 2, your lordship.
Of?
His writ petition, your lordship.
Writ petition.
Yes.
46.
Yes, sir. Lordship, finally. The governor of Assam is pleased to place the services of Sri so-and-so agriculture extension officer of this department at disposal of Panchayat and Rural Development Department as Assistant Project Officer Agriculture in DRDA on deputation, initially for a period of 1 year, with effect from the date of release on the usual terms and condition of deputation to DRDA, including the following conditions. What are those conditions, Your Lordship? Your Lordship, the serial number 3 of that order, Your Lordship, most important. The liabilities for payment of leave salary and pension contribution will be borne by the foreign employer. That is the DRDA.
Sorry, you are reading from page number?
46, Your Lordship. 46. Annexure 2. Order of deputation.
Yes.
The Governor of Assam is pleased to place the services of Sri Sofiul Alam, Agriculture Extension Officer of this department, at the disposal of Panchayat and Rural Development Department as Assistant Project Officer Agriculture in DRDA on deputation, initially for a period of 1 year, with effect from the date of release, on the usual terms and conditions of deputation to DRDA. So he was on deputation to DRDA. And kindly see, Your Lordship, the terms and conditions, the following terms and conditions. The condition 3 is most important. Liabilities for payment of leave salary and pension contribution will be borne by the foreign employer, that is DRDA. Now, Your Lordship, kindly see what is the difference between the PNRD and the DRDA. The DRDA is not a department, and PNRD is a department. DRDA is a registered society. It is created under a scheme. And yes, the state government making financial assistance to the DRDA, but ratio is the 90% of that funding comes from the central government in the rural development, for the rural development department, and 10% from the state of Assam from the PNRD.
How many years of service has he got left for superannuation?
Your Lordship,
53 years old.
Should be
in 21. So it will be around 56. So 60
Maybe.
years.
Maybe.
Now, when was he deputed?
He was on deputation. Order of deputation was issued on 4th of February 1999.
99.
Yes, sir.
Page 49.
Page 46 is the order of deputation, and page 49 is the order issued by the PNRD department. Because, Your Lordship, PNRD department is involved in this affair because PNRD is the nodal department, and DRDA is especially constituted for implementation of development schemes, or so far as, Your Lordship, the poverty alleviation schemes like that. And in the DRDA, Your Lordship, 2 categories of employees are there. Yes. Some employees are on deputation from different departments. Those are skilled in their concerned field, and the others are remaining parts are the DRDA own employees, Your Lordship.
Okay. So your stand is that his initial services was initially under DRDA as per cabinet memorandum.
And he continued
as per cabinet memorandum and subsequent orders with effect from the date he joined PNRD.
Yes, yes.
So on the date he joined PNRD, he is deemed to be an officer of the PNRD.
Yes. Yes, that is our submission, Your Lordship. That is our case. Now, Your Lordship, he continued in the DRDA as assistant project officer till he was reverted back to his parent department, where he was holding the post of agriculture extension officer in the year 2005.
Then there was a stay.
And there is an interim order. He continued till 2010 on the strength of the interim order, and subsequently his writ petition was disposed of, and this honorable court refused to interfere, giving, yes, a liberty was given to him for filing representation, but interim order was vacated. Despite that development, he never went back to his parent department. And he continued because the DRDA detained him. He continued in DRDA, not in PNRD. Your Lordship. And DRDA is a registered society.
Yes.
That is,
Yes, carry on.
yes, Your Lordship. And Your Lordship, his representation, Your Lordship. The file and representation before the Principal Secretary PNRD and requesting him to absorb in the PNRD permanently, and he also identified 2 numbers of posts. He himself identified 2 numbers of posts, including his present post, Deputy Director Training, which was lying vacant in the Commissioner. Now, Your Lordship.
Was there no extension after he was repatriated?
There is no extension. He was only on the strength of the interim order passed by this honorable court, and he continued in the DRDA. He never worked in the PNRD.
So you are saying that between the time when the interim order was vacated
And till his final absorption, he was legally in his parent department. Now, Your Lordship will have to see whether he was absorbed finally in an equivalent post or not.
Yes.
Your Lordship, I would like to refer to the Assam Panchayat and Rural Development Officer Service Rules 2013. Why he was not, how he was not absorbed in his equivalent post.
Yes.
Your Lordship.
Yes, yes.
Kindly turn to page number 386 of my book, Your Lordship. I have separated. This is the table, Your Lordship, under the Schedule 2 of this Rules 2013, Your Lordship. Your Lordship, kindly see the second, Extension Officer Fisheries. His minimum qualification is graduate in fisheries science. And to be appointed as a executive extension officer, agriculture extension officer, minimum qualification is graduate in agricultural science. And his parent department all throughout, he was holding the post of agricultural extension officer. The minimum qualification is the same. And Your Lordship may turn to page number 384, Your Lordship.
Yes.
Your Lordship, serial number 13, Extension Officer Fisheries. That is the scale of pay.
Why are you showing fisheries?
Because, Your Lordship, he was holding a equivalent post of fishery extension officer. Same minimum qualification, same responsibilities he was discharging in his parent department, Your Lordship. Of course, in agriculture.
He was deputed to DRDA as what?
Assistant Project Officer.
Assistant
Project Officer.
What is the post? Extension officer. Fisheries.
Extension officer, he was holding extension officer, agriculture in his parent department, that is irrigation department, Department of Irrigation.
Scale of pay is same.
Scale of pay is same, required qualification is same, Your Lordship. And the nature of responsibilities and duties are same.
But who has taken a decision on that?
Your Lordship, kindly, I'll come to it, Your Lordship. Because, Your Lordship, my learned colleague is referring to the Inspector Ruplal case, Your Lordship, a Constitution Bench judgment which was discussed in the Ruplal case. These 4 conditions were decided, Your Lordship.
That's right, but somebody has to decide it.
Yeah, Lordship. Under what conditions we can determine that some post is equivalent or not? That is it. So here, minimum qualification, nature of responsibility and duties, and the scale of pay, same is, everything is same.
Yes.
So he was holding a equivalent post of extension officer fisheries in his parent department as extension officer agriculture. And on that capacity, he was deputed to DRDA. And in the DRDA, he was holding another post. We are not on this here. Now, Your Lordship, may kindly turn to the page number 373 of the 2013 rules. Rule 5.
Rule 5.
Yes, Your Lordship. 373, Your Lordship, page number.
Yes.
Rule number 5, method of recruitment. Recruitment to the service shall be made in manner prescribed herein after. Clause 3, Your Lordship. Clause 3 is the relevant.
No. Because you don't have rules, there is a cabinet decision. Your rules do not
Your Lordship,
prescribe
Your Lordship.
recruitment
Yes, no.
by
Yes,
deputation.
we don't have any rules for absorption.
Sorry.
We absorbed him. Whether we absorbed him in an equivalent post or in another post or in a higher post. If
It is
he
for you.
is absorbed in an equivalent post,
No,
he
it
will
is
get
for-
the benefit.
It is for you to decide and clarify it. If there is no clarification, then it will be deemed that he is absorbed in an equivalent post.
Your Lordship, what rule says? Kindly see the service rules.
Huh.
Kindly see, we cannot ignore the rules here.
Huh.
Kindly see.
What
Rule
does it say?
5, clause 3, Your Lordship.
Yes.
Recruitment to 80% strength of cadre of deputy director. Training shall be made by promotion, 80% by promotion, and 20% by deployment of ACS cadre officers. So 80% on promotion and 20% from ACS officers, Your Lordship. Then, Your Lordship, kindly see Rule 11. Rule 11, it starts from page number 375. Your Lordship, the next page, clause C, Your Lordship. 80% in strength of cadre of deputy director and such shall be filled up by deputy chief executive officer and assistant development commissioner at equal ratio who have experience of minimum 5 years continuous service in the cadre. So here the cadre post is deputy chief executive officer.
See, you are going beyond the orders passed by your department. You have a look at page number 115 of the writ petition. Page number 115 of the writ petition is very categorical that you get it from the date you are absorbed in a permanent post. This, whatever you are trying to now argue, trying to interpret the rules, was required to be done by the department, explaining that it is because of these reasons he is not entitled to the seniority that he is claiming for.
Yes, in this,
That
in this
interpretation,
order, that is not
that-
reflected,
that-
yes.
No, it's not reflected.
It
That
is not reflected, I admit it, Your Lordship. but-
that is required in view of the fact that in the cabinet decision also, there was no proposal as to how his seniority in the past services is to be determined. Otherwise, it will amount to a break in service. Forget seniority, it will be break in service. That is not what the cabinet said. You have accepted the cabinet decision. You have issued the order. This interpretation at the first instance was to be done by the department. Why should we go into this interpretation when this is not even pleaded? Not even by the respondents.
But when Your Lordship, your law points is involved here.
Law point is very simple, whether his past services is to be counted, not to be counted.
Provided he is absorbed in a equivalent posting. That is the Supreme Court says here.
But you have not denied that he is not in an equivalent post. There has to be you are now trying to refer to the rules. You want to say that deputy director by promotion is to be filled up by assistant development commissioner.
Or by Deputy Chief Executive Officer.
A deputy secretary. We are with assistant development commissioner. Now, assistant development commissioner is to be filled up by extension officer fishery.
Yes.
So,
For having experience of minimum 10 years.
when the person was holding agricultural extension officer and he is now holding the scale of pay equivalent to extension officer fishery, he is equivalent to assistant development commissioner, not deputy director.
Yes.
That is what you want to say.
Yes.
But he is appointed as such.
Despite this, Your Lordship, under Rule 26, we have given him the relaxation and absorbed in a higher post.
Quite right. So if you have absorbed him in higher post, so
Then-
why
then
are you
the-
denying?
Your Lordship, then Your Lordship, question of post of equivalent will come into play, Your Lordship, whether it is equivalent post or not.
It is for you to decide. You have taken a very technical stand that it is from the date when he is absorbed in PNRD, because DRDA is not PNRD, notwithstanding that it is a project under PNR.
If it is so, then Your Lordship, matter will have to be relegated to the
We don't
government
know
again.
what is to be done. You think over, tell us. You think over.
Then
This interpretation of rule is not called for in the absence of any finding by the department. There is a cabinet decision, you have accepted. In the order, you say from the date he has joined.
in the cabinet decision also, there is a indication, not in the decision, but in the cabinet memorandum, indication is there that that particular post is on promotion, promotional post.
Where? Page number?
Page number, Your Lordship. Page number 68, Your Lordship.
68.
Yeah.
Yes.
Your Lordship, page 69, capital A.
Yes.
Your Lordship, the first paragraph. The post of deputy director, such and such are promotional post as per Rule 11C, Schedule 2 of the Assam Panchayat and Rural Development Officers.
Where? 60, oh sorry, 69A.
No, 69, capital A.
69 capital A.
Yes, sir.
Post of deputy director.
Yes, sir. And
Promotional posts.
yes,
Correct.
that indication was there in the memorandum itself.
So, if you look at serial number 9, the proposal was for absorption, permanent absorption of so-and-so under deputation as assistant project officer, agriculture at DRDA. I think it should be one or is missing, or to any equivalent post, subject to correction. The two equivalent posts.
The equivalent post, the fact is that equivalent to extension officer, not deputy director.
No, but you have issued the order.
We have issued the order. Yes, no deniality. But thing is that we absorbed him in a higher post, on a promotional post, giving him
So
relaxation.
That makes things even more difficult for you, because how can you overlook his services rendered in the feeder category? How? Because that service, that seniority will now have to be added to him with the higher post
Your Lordship,
for his further promotion. That is his claim.
Your Lordship, we have exercised their power under 226 of rules given by.
Under?
Yes, Rule 26.
26.
26, page 382.
Oh, how does it? How is this interpretation? Are you trying to now say deputy director? You see, according to you, deputy director is a higher post.
Higher post.
You have absorbed him.
In a higher post, not in an equivalent
He
post.
was earlier working in a post which, according to the rules or according to you, is equivalent to the feeder post from which promotions are made to deputy director, isn't it? He was as agriculture extension officer.
He was in, if we go by the post, Your Lordship, he was on feeder post. He was in the serial number 3, from who is your assistant commissioner, development commissioner, or deputy chief executive officer will be appointed.
No, what was his post?
Then Your Lordship, deputy from the
what was his post in DRD? DRD?
assistant project officer.
Assistant project.
Yes.
So according to you, assistant project officer is equivalent to assistant development
Your
commissioner.
Lordship, he was on deputation. Whether he was holding, it is not mandatory that he will definitely hold in deputation equivalent post.
Ordinarily.
So that will not come into play. While Your Lordship absorption will come, then Your Lordship, this question will definitely come whether he is absorbed in an equivalent post or not. That to be seen.
So what have you done, according to you?
Your Lordship, we have absorbed him
Where?
in a higher post.
A higher post.
So if it is higher post, promotional post, he was not in that cadre even in his absorption, Your Lordship.
Whatever, but you have passed the order and you have not recalled.
We have not recalled.
You have
We
passed
have
the
not
order.
recalled. We have given certain explanation also.
Where?
In the page 115, Your Lordship, that we are saying, yes, we are saying that his date of, from the date of absorption, from the date of his joining, Your Lordship, it will be counted. Last paragraph. Later on, as per the approval of the Honorable State.
Correct. That is what you are saying.
Yes, sir.
The date of joining in a permanent post in PNRD department.
Yes.
So
Then Your Lordship, the
he was posted in DRDA by PNRD department.
Your Lordship, kindly see the order of deputation, Your Lordship.
See the order.
We are involved because we are the nodal department.
Whatever it may be.
DRDA cannot call someone from another department on deputation. So the scheme of things is there. Your Lordship, the administrative, under the administrative guideline of the DRDA, these things are done.
See the order of deputation, page 46.
Yes, Your Lordship, kindly
He is
see.
placed at the disposal of PNRD.
Because Your Lordship, his parent department cannot place him in a DRDA directly because they are not the line department. They are not the nodal department.
Exactly. But once you place him under PNRD, he is a government servant. He is a government employee.
Your Lordship, as per the administrative guideline of the DRDA, some percentage of employees comes from other government departments on deputation.
Exactly. It is to be deemed to be a service under PNRD department.
No, Your Lordship can't, because Your Lordship, DRD is not a department. It's a registered society.
You are not, this is not a direct recruitment. It is not a case where.
No, it is not, doesn't require even, because on deputation, they can come.
How can a government servant be placed in a non-government post?
Your Lordship, suppose he continues in his parent, till he continues in the parent department.
No. Your argument is fallacious because you are saying that he was placed under DRDA, which is a scheme or a project, not.
It is not that, Your
entirely
Lordship,
under.
while he was working in the DRDA, he was holding lien over the post in his parent department.
This argument, we need not get into it. We can straight away say that we reject your argument. This is not done. How can you, a person applies for deputation to a department, under the orders of the government, he is placed under the department, you tell him to go there.
Your
And
Lordship,
then
the
you say,
order-
no, this is not under our department.
This is Annexure 2, Your Lordship, is an order issued by his parent department itself, Your Lordship.
Correct.
And they are saying
In the name of
that
the governor.
the foreign employer is the
No,
DRDA, name of the governor.
See the first line. In the
Yes,
name
the
of the
governor, name
governor.
of the governor. Kindly see, Your Lordship.
In the name of the governor.
Liabilities for payment of leave salary and pension contribution will be borne by the foreign employer.
Maybe.
That is the DRDA.
Maybe. We cannot accept it. This is not an argument that you can make today. You cannot. He has applied for deputation, you have accepted it. You call the file for deputation, your borrowing department's views will be there. You see the file. Yes, what do you say about the judgments?
Your Lordship, the other side has relied upon the SI Ruplal judgment, and the paragraph 17 is most important. And the paragraph 17 says that if he is absorbed in an equivalent post, then he will get the benefit of his past service. Our stand is that as per rules of the service rules, the post where he was against whom, which he was absorbed, Your Lordship, it's a promotional post, much higher than the post he was holding in his parent department. So he was not absorbed in an equivalent post. And since he has been absorbed in a promotional higher post, his entry into that cadre starts from his joining after absorption in that particular post. So his past service, so far as seniority is concerned, cannot be considered.
Yes.
That's
okay.
why.
Okay. Hard reserve.
Your Lordship, so far as his gap period is concerned, after reverting back him to his parent department, he was continuing in the DRDA. Your Lordship.
Yes.
Your Lordship, since the DRDA is a registered society, and Your Lordship, for every action taken by it is not cannot be answered by us also, Your Lordship. That is not our responsibility.
Huh?
Cannot be binding on us also. Because, Your Lordship, kindly see, after vacation of the interim order, he ought to have go.
That is one issue we'll take into note of. But to say that because he was put under DRDA, he's gone under the purview of PNRD would be a little perfect.
Your Lordship, so far as that part is concerned, Your Lordship, I am relying upon the
rules আছে না ভাই এটা সার্ভিস
I am relying on judgment of Camel, Your Lordship.
Oh.
Your Lordship, about the
citation,
Your Lordship, I have provided the copy.
What is the citation?
2009 5 SCC 694.
Okay.
Paragraph 10 and 11 may kindly be seen.
Yes.
And another is your lordship, Steel Authority of India Limited versus National Union Waterfront Workers.
Para.
That 2001 7 SCC. Para 17 euro.
17.
17.
17.
Para 17.
Then 2000 volume 1.
Yes, sir. 7 SCC.
Yes. Yes. Next.
This one is discussed in the Camel judgment also.
Yes.
In the Camel judgment, we will also rely upon the page number paragraph number 23. 23. And the Steel Authority judgment 37 euro paragraph.
Yes. Okay. Then Ruplal.
Yes, sir. Ruplal.
Ruplal, which paragraph?
Paragraph 17. Euro.
17.
Yes.
Okay. Then
This is Koluna.
what is the last judgment for?
This is the Steel Authority. Euro.
No.
Camel.
2023.
Oh, yes. Yes, your lordship, in the read petition, the other side has relied upon certain office noting, your lordship. That is not binding. Your lordship. As far as judgment, paragraph 17, your lordship. Paragraph 17 may kindly be seen, your lordship.
Para 17.
Yes, sir.
Yes. Okay.
Yes, sir.
Thank you. Yes, we are closing the hearing.
Yes, sir.
Anything to submit? Okay. Heart reserve.
Time for respondent.
Mr. R.K. Talukdar for respondent.
I am replying respondent number 2, Lord.
Mr. A. Chakraborty for respondent 2. Itu order
Oblige, your lordship.
Yes.
Sorry, my lord, in between, I had to leave the court for some medical emergency. I'm back. My lord.
Everything all right?
My lord.
Yes. Hello.
My lord, I have already submitted my lord. On the basis of the earlier judgment, only the benefit of 16.5 has been given. Only thing is that, my lord, they were asked to pass a speaking order providing the benefit. But instead of that, they have said, my lord, in view of division bench judgment of Arunachal Pradesh, the petitioner is misquoted judgment. So now I have shown, my lord, as regard additional pension, that the State Chief Information Commissioner has been given the benefit of additional pension. They have did not make any rules, but the benefit has been given to him.
I think on the last order, we
Yes, your lordship has
requested the respondents to find out if there is any rule or order made for additional benefit.
Yes, my lord, lordship has sought for specific instruction, my lord, with regard to
My lord, that page number 58 of the writ petition, that document
Hmm.
at annexure 19.
Yes.
My lord, I have taken up the matter with the finance department. My lord, they say that, my lord, they are not a privy to this document, so they, my lord, cannot give any instructions.
So who will give the instruction?
Now, instruction will have to come, my lord, from the Administrative Reforms and Training Department. That is, my lord, the PPG department.
Who is for the PPG?
Government. On the last occasion, my lord, the additional senior government advocate J.K. Goswami, my lord, he was there. Lordship has directed him.
Sir, the time will be required. Some time will be required, Lordship. They have stated one communication letter, Lordship. So some time will be required for obtain the instruction, Lordship. That instruction 29-2, Lordship. 24, Lordship.
No, no, we don't want any further instructions. If you have a copy of the writ petition, please see page 58. This is an order
Lordship.
passed by the administrative reforms.
Lordship. That instruction, Lordship, that.
On what
annexure-
basis this revised pension has been provided?
Lordship.
How?
One letter has been communicated, Lordship. And that there is
How
no
much time
instruction
do you
received,
require?
Lordship, till now, Lordship.
How much time do you require?
3 weeks, Lordship. 3 weeks, Lordship.
3 weeks only to find out whether what is the big.
Then 2 weeks, Lord, 2 weeks, Lord, 2 weeks. Lord.
But I pray, my lord, let the matter be taken up next week. They will just get it from this school, my lord.
That's right.
Yeah,
It will be listed on 15th.
Yes.
15 March, you get the instructions by 15th. Do you have you take a copy of this order?
Then 19, Lordship, kindly 19, Lordship, 19 March. Lordship.
All right, you take a copy of this order 29-2.
Lordship.
And Mr. A. Mr. Gorpujari, Learned Counsel for the Finance Department submits that since it is the Department of Administrative Reforms and Training Department, which has now been re-nomenclatured at, what is that? ARTPG and PP, or
Yes,
something like that.
Right. But earlier it was, my lord, Pension and Public Defence Department. Now it has been, my lord, reclassified as, my lord, Administrative Reforms and Training Department.
Administrative Reforms and Training and
Department,
my
lord.
Therefore, the Finance Department does not have any instructions.
Well,
Stop. Mr. A. Chakraborty, Learned Government Advocate, submits that he has received instructions that the department seeks for further time to complete the instructions and further time to furnish the instructions. Mr. B.D. Das, Learned Senior Counsel, assisted by Mr. H.K. Sharma, submits that this matter be listed on a fixed date. Accordingly, let the matter be listed again on 19. On 19.
19, Lord.
Is 19 convenient for you?
Yes.
19th.
My lord, I've been
19th
informed that they have
19
the
March.
records. They have the records relating to the whole affair.
Stop. The relevant records pertaining to the issue may also be kept ready for perusal of the court if so required. On the next date fixed, an attempt will be made to dispose of the writ petition.
Problem.
His name will be reflected.
It's okay.
He will not appear. The case will go again.
We are making it that if you are not there, we'll dispose of it. Whatever is there. Yes. We have received the report. There is no charge sheet filed.
Lordship, the charges filed by the police, Lordship.
It is not filed. That is the report of the CJM.
Lordship.
Very categorical. FIR could not be traced out. Very old pending case. And there is no evidence of receipt of the charge sheet by the PI office.
As part of the report submitted by the
Which report?
Lordship, Lordship, may kindly turn to the page 31 of the writ petition. Paragraph number 12, Lordship. And,
Is there any departmental proceeding pending?
there is no department proceeding. Only because of, my lord, that criminal proceeding, my lord, there we have, my lord, not taken any action.
Heard learned counsel for the parties, this writ petition is filed by the petitioner. Praying for release of, praying for issuance of a writ of mandamus or a writ of like nature for release of his service / pensionary benefits, including gratuity, leave, encashment salaries, along with interest withheld by the respondent on the ground that the criminal proceeding is pending against the petitioner. Stop. The said criminal proceeding is stated to be on the basis of an FIR lodged and registered as Polton Bazar PS case number 189 of 1999. Stop. Earlier, during the course of the hearing, opportunity was granted to the respondents to apprise the court as to the status of any proceedings that may have been pending before the against the writ petition. So an affidavit was filed on behalf of respondent number 2, wherein it was stated that subsistence allowance have been released to the petitioner. So in the said affidavit, there is also an averment that the pension has not been released in view of the government notification number PPG within bracket P 7/2012/8 stated 21/06/2012, whereby government servants, retired government servants against whom disciplinary proceedings or judicial proceedings are continued, no DCRG shall be released to him until the final conclusion of such proceedings. Have you received your pension?
Provisional pension he is receiving, madam.
You have received.
Provisional pension received. But
Stop.
other allowances.
Since, as per the information available to the department, there is a criminal proceeding pending against the petitioner arising out of Polton Bazar PH case number so and so, in which charge sheet has been stated to have been filed. The DCRG in terms of the above notification has not been released. Correct. In view of the averments as well as the submissions made by the government councils, this court had called for the report from the CJM's court as to the status of any judicial proceedings pending against the petitioner arising / or in connection with Polton Bazar PS case number so and so. Stop. A report has now been furnished to the registry and which is placed before the court. Stop. As per the said report, there is no evidence of receipt of any charge sheet. Sorry, you write that according to the officer in charge of the Polton Bazar police station, a report was submitted stating in the incident case charge sheet, ID charge sheet number 121/2014 dated 3007/2014 was filed, but the receipt register of charge sheet lying in the PI office within bracket Kamrup Metro, Guwahati, comma, there is no record / evidence of receipt of the said charge sheet by the PI office. Stop. It is further stated in the report that prior to the year 2008, all police case records / police papers were handled by PI office, and there was no GR branch to handle all of this matter at the time. Stop. As the FIR could not be traced out, as this is a very old pending case, further time is sought for. Stop. In view of this report, let the registry call for a detailed report from the office of the CJM, and the report be placed before the court by the next date fixed. Let the matter be listed again on 5th of April. 5th April.
My lord, petitioner is a cancer patient, lordship, when he is bedridden, lordship.
You have
So-
received provisional pension.
Yes, provisional pension receiving, my lord.
Then
But my lord,
there is a report saying as on date it is not there, but the CJM is sought for some time to complete the
already,
inquiry.
lordship, CJM has taken 3 months of time, lordship. On 1/12/2023, lordship, we will, my lord,
All right, let the matter be listed again on 20 March,
20 March.
by which date the CJM is expected to, the report is called for from the office of the CJM in regard to Bolton Bazar PS case number 189 of 99, and as to whether any charge sheet has been filed in the matter, be called for by the registry and placed before this court. Yes, what do you say?
Only allegation, he is the owner of the EMI, registered. After 6 months, he was arrested. 6 months, my lord. After 6 months, he was arrested, your lord. FIR is page 18.
What is the finding? What are the materials here?
Except owner, nothing.
My lord, here, from the vehicle, my lord.
No. You have examined this.
Examine, I have.
What have you found out?
My lord, found out he is the owner of the vehicle, my lord, which was seized in connection with the, my lord, yes, my lord, and that from that, my lord, secret chamber, my lord, 1434.53 grams of heroin was seized, my lord.
He was driving. He was present in the vehicle.
No, not present in that. He is the owner of the vehicle, my lord.
What vehicle is this?
It was, my lord, Bolero, my lord. Bolero vehicle, my lord. And from the driver itself reveals that, my lord, from the secret, my lord, it was.
It's a taxi.
No, Bolero vehicle.
Bolero.
No, my lord. No.
Meant for hire or a private?
Private.
That is private one.
Private vehicle.
It was sold, my sale details also available, my lord. Page 20. And my lord, date of occurrence 11/11, arrested on 2/5 after 6 months, my lord. Only because when they found that the paper shows he is the owner of the vehicle. Nothing.
Only what?
Only that he is the owner of the, my dear, kindly see page 18 in the FIR. Your kindly see page 185. Page 18. Page 180, your lordship will find.
The trial.
My lord, trial is going on, my lord. And
not yet evidence partition.
one PW was examined, my lord.
Charge was framed on 26/10/23. Charge frame. And your lordship's order is 16/10/23. Rejection order. Page 45. 16/10/23.
My lord, one PW was examined on 22/24, my lord. And on that, the defense counsel has taken adjournment, my lord, not cross examined, my lord.
Yeah.
Evidence PO1 leave देखिए हमें 20 तक PO1 leave देखिए
No, 20
सो
20
और 20 PW action
one examined.
Huh?
One examined.
Sure नहीं.
Concorder.
Huh?
Concorder.
What happened to the other bail petition?
All granted by. Who granted by the court?
Where are the orders?
Oh, the next minor, you'll kindly see that order, my lord. Two granted by the court below, and one is granted page 54.
No, there are as many as 5 bail petitions shown here.
Well, 3% already got bail. One is present one. Okay. 3% got bail on Najimuddin, Sharimuddin, Jamaluddin. It is page, my lord, page 54. Jamaluddin. This honorable court, my High Court passed, and other 2% court below. That is reflected in that order.
Samiluddin. Who is Samiluddin?
Saminuddin.
My lord, he is the driver, my lord. Driver of the vehicle, my lord.
No, Salim.
How is it that
He is still in custody.
in your vehicle you don't know?
But my after 6 months, your lord kindly sold it
6 months, 6 months because you were not available.
Not my lord, not at all, my lord. I have never, my lord.
Where is the sale deed?
Yes, page 20, your lord. P922. Your lord kindly say FIR says, my lord. I just take your lord FIR. FIR page 19. Page 19.
Yes.
In the vehicle they found. Police by FIR they're saying, my lord, page 18 start and page 19 top. One sale deed of registered number so and so having chassis number so and so, vehicle number so and so, as issued on 3rd September 22. 3rd September 22. In between Tajuddin, son of so and so, present petitioner, and on abolition, son of so and so. This is what they have seized. Except this, nothing, my lord, against it. Nobody has stated that it is I have.
No, but what is the value of this sale deed?
My lord, lordship may kindly please the.
My lord, fact is that, my lord, my conscious position, your lord kindly see, let it goes, my lord. You are arresting me after 6 months. I am not named in the accused except this one. Except this, nothing. I am also named. There is no question of absconding also, my lord. I am also named in that sense, my dear lord kindly. Your lord kindly, the name of the accused person, your lord kindly, name of the accused, page 19, bottom. My name is not there. Page 19, bottom. Shamiruddin, Najimuddin, Jamaluddin, Salimuddin.
Your name is not there because
Not there.
need not be.
No, so there is no question of absconding. What your lordship is saying that 6 months I was absconding, my lord.
No, I'm not saying that.
Yes. Now
I am saying that you are being arrested after 6 months.
After 6 months.
Whatever the reason is, does not necessarily prove that you are sitting at home and suddenly.
So
came
the
and picked you
question,
up.
first question of conscious possession is there or not? Whether I was at all, I had knowledge about this or not.
That's right. So therefore, your sale deed will have to explain everything. Where is the sale deed?
Sale deed you have next, my lord, page 20.
20.
Yeah.
This is not sale deed.
Not sale deed.
Sale deed in this, not a registered, my lord. Page 20, 20.
20 is not the sale deed.
20, my lord. Oh, sale deed, I'm sorry. This
Not
one,
here.
not, I'm sorry.
My lord,
I am saying, my lord, sale deed in between so and so, page 20 means, my lord, I am saying about this FIR part, my lord. Page 20, my lord, subclause 3, my lord. The mention about this, my lord. It is mentioned already, my lord.
Correct, it is mentioned, but
They have
this
seized all it, my lord.
You are relying on this for what purpose?
I am relying that it was sold on 22nd September.
That's right. So you must be having some copy, retained some copy.
It is there. It is there. They are saying it is with them. It was in the vehicle.
You have sold the vehicle.
Yes. Sold the vehicle
to somebody.
Somebody.
Are you telling me that you have no copies of the sale deed?
Madam, that I am not saying that I have.
Then
I am saying, madam, it is because they have seized one.
That we can
so
read. That a
authenticity
copy of
cannot
the
be.
sale deed was available in the vehicle.
That
has been taken into custody by the.
They have not doubted about it. There is no doubt about it.
They may not have doubted because you have to satisfy that this sale
No,
deed.
madam, this sale deed, madam, nobody doubt there. Nobody questioning this.
It's not about nobody. We can certainly doubt.
Your logic can question.
We can question it.
Certainly, madam.
Yes.
I am saying investing authority, they have not doubted about it. That is
They
right.
may not have doubted because, which is why charge sheet has been filed and the matter is in trial now.
No, charge sheet is filed, but because
Where
only
is the charge
because,
sheet?
only because of this sale deed.
Charge sheet is, I have take mark, my lord. Lordship, regarding the, my
Charge sheet
lord,
is page 20.
regarding sale deed, my lord, I have a
Nine.
submission that, my lord. Lordship may kindly peruse the, my lord, rejection order, my lord, lower court rejection order, my lord, 2012-23, my lord.
একটু এপিল কোথায় লোক Yes.
Lordship, regarding the sale deed, my lord, Lordship may peruse the rejection order of the court below, my lord, observation regarding, my lord, sale deed 2012-23, my lord.
Page 1, page.
Is it enclosed to the petition?
Not included, my lord, in the scan copy, my lord. Two occasions they have taken the plea that, my lord, sale deed was done. But it was found that it was, there is no any seal signature, my lord, in the sale deed, my lord. It was reflected in the order copy, my lord. That is 2012 rejection order, I have taken now.
Okay, 2012.
2012.
My lord, 2012, I have taken mark, my lord, rejection order.
Correct?
My lord, 23, my lord.
2012,
23, my lord.
23.
My lord.
No,
I take mark, my
আমরা
lord.
রেজিস্ট্রেশনটা কোথায়? এনে রেজিস্ট্রেশনটা কোনটা হয়েছে? গাড়ি রেজিস্ট্রেশনটা হয়েছে তো অর্ডার।
Yes.
My lord, in the lower part, my lord, last part, my lord.
কি পারবে না? ফলো করে লাগিয়েছে তো।
Does not bear any signature of the buyer.
My lord.
Not 27.
In the earlier occasion also, my lord, that is 7/6/20.
Merely executing a deed is not sufficient to complete a transfer of property.
I am not on that.
Still in the name of the present.
My lord, my only question was, you have seen, you have found the vehicle, you have found 4 persons in the vehicle. They have also not stated my name. I was not there. It was not in my, not even conscious, not even in possession also, my lord. Not to say conscious possession. Now you got 4 persons there and they have also not stated. Even they have stated that also Tufan Singh is there, my lord. They cannot do it, my lord. Now you are arresting me after 6 months only because you got a sale deed there in that year, my lord. You have arrested only on that ground. Nothing, no, even charge sheet also it is not there, my lord. You have gathered anything against me, my lord.
Charge sheet.
Yes, charge sheet page 29, I have annexed, my lord. Page 29, your lordship. Page 30, your lordship will find. Tajuddin. Tajuddin, your lordship, page 35. My question, nobody has stated anything. No whisper against me, except that one. I must have some connection with the contraband which is seized by them, my lord. They have also stated.
Where is the forwarding?
My lord, forwarding, I have
It
taken
is
mark, my
there,
lord.
my lord.
Forwarding, my lord. Take mark, my lord. I have taken mark. Forwarding, my lord. Two forwardings here. One is the other person.
2
and
persons, one Jamaluddin and Tajuddin, my lord. Jamaluddin he already got bail.
You are Tajuddin.
I am
Tajuddin, my
Tajuddin.
lord.
Your lordship is dated 2nd May 23. About me, your lordship has grounds of arrest, your lordship. The arrested accused Jamaluddin is the mastermind, who is already got bail. Then number 4, your lordship will find. The arrested accused Tajuddin is the owner of the vehicle bearing number so and so from which 17 so and so containing suspected heroin were recovered. Both the arrested person are involved in trafficking of drugs for a long time. How they came to this man?
What about Jamaluddin?
Jamaluddin bail order is, your lordship will find page 54. This high court. Page 54.
54.
Yes. 29/11/23.
Jamaluddin is a driver.
No, no.
Jamaluddin,
No.
they are stating, my lord, they are all the three persons who are there, my lord. There you go.
Driver is the
So
Samiluddin. madam.
Jamaluddin was arrested subsequently, my lord, along with me, on the basis of CDR, my lord. Your lordship will find that is there in paragraph. Yeah, and he is a fire name accused. But paragraph 15, page 58, my lord.
Any material in respect of their earlier involvement?
No, no. That is not reflected in the forwarding. of-
Page 58, paragraph 15, man.
Where is the earlier rejection order?
Order resolution, this was enough for page. Your lordship's order.
Yes.
Oh, your lordship was at page 45.
45.
45, man.
No, 45, your lordship, my last page. Page 49, your lordship, man. So basically, my child not paying, and that's why your lordship. And Bolinder Singh, we have referred, your lordship stated that after the judgment. So your lordship has stated that we have that. Bolinder Singh to us. Paragraph 4. That is Bolinder Singh, your lordship is mentioned all.
Now, how has the situation changed in respect of para 12?
Well,
Yes, there's only one witness.
Madam.
one, so your lordship and your lordship order dated 18/10/23.
Oh, but the reason for rejection is
But length of
effectively
my question by prima facie whether 37 I overcome or not, mine. Whether 37 comes or not, mine.
so it's a matter for an appeal. You go and appeal.
No, I don't that. I'm not on that part. Whether your lordship is to see 37 is there or not. If 37 is there, of course it is up to your lordship, mine. Here there is no connection with the contraband. Nothing is there, no whisper against me, except the sale deed, mine, which was found in that. Nothing. Nobody has even said that, but I am involved also, mine. And Perity also, that person already 2 persons arrested. He is involved. In my case, only my that is there. So 37 is also not coming, my lord. Prima facie, my lord, I am not guilty. There is no past incident also that I am involved myself in this type of offense. That is also not there. Something must be there, my lord, to connect me with that contraband, with the offense.
Sell deed.
Sale deed, my lord, that is the one. Can it say, my lord, because I have put it there? After 6 months, you were somebody something got from the car.
You are relying on a sale deed.
I am not relying. They have got the sale deed, so they arrested.
You are not denying that.
But I am not, because it is a fact, but I am not relying on that. I am saying
You may
that
not be relying, but you're
saying
not
they have
denying on that.
sealed. They have arrested only because sale deed was there.
Correct. because they'll think you are the owner.
I'm the owner, I am saying I was the owner, I was the owner.
You satisfy before the court that yes, this sale was lawfully executed. I am no
That-
longer the owner.
That might
End
your
of the
lordship,
story.
no sale, transfer of vehicle, normally, so many formalities are there, my.
You
Then only
show,
it
you show
executes.
us that form under the motor vehicles that
Madam, I am
is
the,
transferred.
leave your, aside everything, madam.
Right.
My connection with the contraband, anything is there, madam, my land, let him show my, anything, any whisper by anybody, that I was this way involved in this offense, madam. Anywhere, anything is there. Severe is there, anything, if there is anything, I have nothing to say, madam. Only because I am the owner, my of the cell deed is there, on there. Suppose cell deed would have not been there. My name also would not have come in the charge sheet also, madam.
That is why we're asking you, para 12, I've given the reasons why I rejected the
Your
bail.
lordship is reason, madam, because that was after the evidence that Bolinder Singh, that your lordship is given.
That's right.
But the ultimate question by law is the same, madam. Here also your lordship, for the charge sheet also your lordship, except this, nothing is there in the charge sheet also. Nothing is there, except this.
We pass some order letter.
My connection only, if there is any connection with the contraband, I have nothing to say.
That is the whole purpose of the trial, to find out the connection.
But should I remain there?
According-
Should I remain for indefinite period, my lord?
Ordinarily not, ordinarily
Madam,
not.
should we remain for indefinite period? Only for
Ordinarily
that
not,
purpose,
but this is NDPS.
My lord, NDPS, my
That's
lord. Organized
true.
crime, my lord.
And NDPS, it is true, equally, Supreme Court, time and again, say, your lordship also stated, my lord. It is there, in NDPS, not that nobody can get bail, so many people are getting bail also, my lord.
That's right, it is a discretion.
Now the
You-
but
you-
here, no, what is my connection with the contraband, my lord?
We don't know. We are just.
No,
we
your
just
lordship
ex-
must know it, my lord,
No,
from the records.
we are exercising a bail jurisdiction, not
My
an
lord,
appellate
But
jurisdiction.
prima facie must be there, 37 your lordship to see.
That is prima facie view we have
Fire,
expressed.
fire from there can say, my lord,
We,
prima facie.
we had expressed in para 12.
My lord.
We
In the
did not
earlier-
go
Your
into-
lordship, I am not saying your lordship, because they have got some materials. For material, they
Mr.
must show, my lord,
Mr. Counsel,
my lord.
there is no review jurisdiction in criminal.
No, I'm not reading, I'm saying, my lord,
The view has been expressed in para 12.
you might, your lordship.
I have expressed my view.
No, your lord, yes, your lord, can see, my lord, what your lordship has stated.
You now
One
want
scanned
me
copy
to,
of the
you
LCR.
now want me to take a different view.
I'm not saying, there, I have come for the detention, my lord, since nothing,
How many days?
no improvement has been
How
made,
many days?
my lord.
How many days?
Your lordship, that, oh, he is in custody 307 days.
Hmm?
307 days. Why he is there? Same person who is named in the bag already got paid. And no whisper, I am only on that, my lord. No whisper against me by anybody. And other accused already got paid. Other accused did not say about my involvement also, my lord.
That we don't know because the
No,
matter is in
they must say,
trial.
my lord.
It is only when the trial court says
My
that
My lord,
there is no evidence.
my lord, because bail up to till today, whatever material they are having, they must show, they must say, yes, this is the involvement, why his custody is required, my lord. There is nothing, no whisper, my lord. Whether I have a connection with the offense or not, my lord.
Where is the bail of the other accused?
Yes, that I have just shown, my lord.
Page number?
Yeah, that is that one. One is page, your lordship will find page 54. The Jamaluddin along with me, he was also there.
64.
Yeah. He is named in the FIR. I'm not named in the FIR also. My. 54. That Jamaluddin along with me, he is there.
We'll see what orders we can.
That's so sort of. My only question, my your lordship, because they must show my lord whether any involvement is there or not. I am only on that, my lord. Only for suppose my lord trial, your lordship has stated yes after trial, my lord. It will take 6 months, 1 year, 2 years, it may take, my lord.
My lord, these are the
Oh, his
organized.
liberty is also, it is also in NDPS, liberty is also there, my lord.
See the reason why people are put in custody is because of the apprehension that in the event your presence is required, you are not to be found anywhere.
No, it all depends on somebody from Manipur, Nagaland, Tripura. I am here and permanent resident there in that particular place, my lord.
Where?
Karimganj.
Karimganj.
Yes, my lord. Permanent resident there, my lord. It is not their case also, my lord, that I will flee away. Whatever condition, I am there, my lord. Certainly, I'll have to.
You must have a residence in Mizoram also.
No, no.
Because your
My-
car is registered.
registered
in
in
Mizoram.
Mizoram, my lord.
My lord, I had a car for Mizoram. I registered for Mizoram. Tax is lesser, my lord.
Who?
So-
Who had a car?
I means, my lord, we had a car in our family. why I have said, why
That-
Mizoram registration, my lord?
That we don't know.
No, registration means Meghalaya, Mizoram, they
We
get.
are not hearing, we are not hearing that.
Tax is less, so people are getting registered.
We are not hearing.
Anyway, my only, I am not that, my lord.
Under the rules,
My,
under the rules, you must have a place of residence.
yes, I am, yes, you kindly say it. So, permanent resident of the address I have to.
Where?
Going on.
So there is another residence must be.
No,
my-
I must show that, yes,
How have you got?
How
a
it is
residence?
registered in,
but unless it is rebutted by somebody, it cannot be presumption I have a house in Delhi.
That's the mandate of the Motor Vehicle Act.
my lord.
Oh, my lord.
Permanent
My lord,
residence.
my lord, they cannot presume that I have in a house there. My lord.
Presumption is in view of the statutory provision.
No,
It is
that
there.
presumption will come when
You
presumption, this question arrive, then
I
presumption. will
cannot
come.
go and register a vehicle.
Nobody is questioning, my lord. Whether they have question that I will play away.
We are asking you, we're not even questioning you.
My question, my lord, I have stated I am permanent resident
We'll
of.
see what orders we
My
can
lord,
pass.
my lord. I have the objection in this.
My,
Yes.
yeah, my objection without any basis, my lord.
No, no, no. my
That is
lord.
why I am saying, my lord.
Shall
Yes,
it-
I respect my lord,
No,
but
no.
they must have some basis, my lord, for the objection. What is the basis of our objection, my lord?
We'll pass orders.
My lord, my lord. Shall it is not, signature is there, my lord. It is an organized crime, my lord.
Leave aside,
And
my lord, I am not relying
vehicle
on
is
self-date,
not
my-
even transferred till today, my
No,
lord.
I am not relying on
If it
self-date.
is organized crime, then why in your charge sheet and everything, it is not there in
But-
detail?
My lord,
Nothing.
Not details, but their names is there, my
I'm
lord.
not
Charges
even
are you
simple.
submitting that
Right.
this is organized crime?
My
It is organized crime,
Right.
but whether the petitioner is connected to that
my lord.
is,
Vehicle is,
is for you to find out.
he is the owner of the vehicle, my
And you have put him behind bars for 307 days for
Right.
what purpose?
Only one witness is examined till today.
Why?
And other accused who did not say anything about me also.
Which
Namely,
accused?
That is
other
co-accused
accused who
statement,
have been there, my lord, they also did not say anything.
co-accused
They also-
statement not relevant at
No,
present.
that is also there. Even they did not say much. But something must be there, what I am saying, my lord. Anyway, I lift your lordship, my lord. Obliged.
Yes, please.
Obliged.
On the last occasion, my instruction was called for, my lord, as to the later notification dated 1/9/2000.
Lordship, I have received the instruction, Lordship. This notification of 1/9/2007, 2000 is of the finance department. It is not related to the child literary trust, Lordship. This is a notification for revision of that minimum entitlement of the earned leave. Earlier it was 240 days. And by way of this notification, that has been revised to 300 days, minimum entitlement of earned leave. Nothing else, Lordship. And I have placed before Lordship another communication from the Secretary Child Literary Trust to the Secretary Education Department, whereby they have already elaborately said that by way of a resolution in 2016, Lordship, from 2020, they have started paying these encashment of leave and gratuity from their own source, Lordship, not from the government. That single page letter, communication letter is there. Of course, that is in vernacular, Lordship, which speaks everything, Lordship. And that extract of the resolution is also there in the overleaf. And in this present case, the petitioner has retired in 2012. From 2020, they have started paying encashment of leave and gratuity from their own source of fund.
Yes, what do you say, Secretary?
Lordship, so far as this decision is concerned, Your Lordship, verbal instruction that I have, Your Lordship, is that from 2020 they have decided to pay, Your Lordship. And in 2016, they have adopted a resolution to create a fund for Your Lordship, this, Your Lordship. The gratuity, Your Lordship.
This gentleman is retired.
Retired in
Yes.
the year 2012, Your Lordship. That's the problem, Your Lordship. At the relevant point of time when he retired, Your Lordship, that provision is not there, Your Lordship. Now, Your Lordship, by separating 5% of the earnings from the sellings of books, Your Lordship, there.
This trust, who takes a decision? The
Your
trust.
Lordship, there is a committee, Your Lordship, that committee.
Trustees.
Trustees. Your Lordship, trustee,
So you file an application before the trustee.
My lord.
Lordship.
And you
They
look
will,
into the matters and see if some relief can be granted.
Lordship, that will be better.
Heard learned counsels for the parties. This petition is filed by the petitioner, who was initially appointed as production editor in the office of the Children's Literary Trust on a part-time basis on fixed emoluments. Stop. These services were regularized in the year 1990. Stop. After rendering his service for about 22, 23 years, petitioner superannuated from the post on 31/3/2012. Stop. At the time of his superannuation, an amount of rupees 421,334 was found to be payable to the petitioner as area salary.
That has been paid.
Stop. That apart, it is the claim of the petitioner that post-retirement benefits like leave encashment, gratuity, etc. were also required to be paid to the petitioner. However, in spite of several representations, notifications, representations and petitions, the grievances were not redressed. It is submitted by learned counsel to the petitioner that the trust was set up with funding issued by the
Grant in aid, Your
by grants in aid issued by the Department of Education. Yes. The relevant point is stop. These grants in aid are periodically provided by the Education Department, and therefore, Education Department for payment of salary and other dues as permissible. Stop.
Only salary, Your
Learned counsel for the petitioner submits that in respect of other employees, there are instances where leave encashment was granted and the same was also enhanced as per the uh, revision undertaken by the government. Stop. Under such circumstances, the petitioner has approached this court praying for a writ of mandamus to the respondent authorities, including the trust, for issuance of the area salary and other retirement benefits. The respondent 3 filed their affidavit in respondent 3 filed its affidavit admitting the claims of the petitioner. However, it disputed the claims of the petitioner that the petitioner is entitled to retiral benefits as there is no such provision adopted by the trust. So, the learned counsel representing the trust has taken a plea of maintainability of the writ petition inasmuch as the trust is it is not a trust formed under any statute. The only issue is with regard to receipt of funds from by way of grants in aid from the government. Government has not filed anything.
No.
Yeah. The state government, the education department did not file anything. There are learned counsels for the parties have been heard, meetings have been carefully perused. Since the matter is being taken up for hearing after admission, the question of maintainability is no longer available as have been held by the Petitioner judgments rendered by the apex court as well as this court in this connection. So, be it as it may, during the course of the hearing, the learned counsel for respondent 3 submitted that the area salary has in the meantime been released, to which the writ petitioner, counsel for writ petitioner does not dispute. Stop. The only question remains is whether the retiral benefits, in it, if any, are to be granted to the petitioner. Learned counsels representing the respondent submit that with effect from
2020 or
2020, leave salary, leave encashment
lots
has been
and gratuity.
And gratuity has been decided to be issued to the employees. And for that, a particular fund is earmarked by the trust. Out of the, you are still receiving grants in it.
Not from the grant in it, sale proceeds from the book.
From the sale proceeds of the books. So, learned counsel for the trust submits that such amount is now periodically determined and kept aside.
No.
So, Hera, upon careful consideration of the submissions made at the bar, it is seen that the decision to pay leave encashment and gratuity was taken in 2020, and a specific fund has also been earmarked. However, there is no dispute on facts that the petitioner superannuated in 2012.
Yes.
2012. And his leave salary was also released belatedly. So, under
No,
the
area salary.
area salary, belated. So, under such circumstance, considering the fact that the trust is presently maintaining a fund for release of leave encashment and gratuity, we deem it appropriate to permit the petitioner to approach the authority, namely the so trust, and file an appropriate application seeking the benefit of leave encashment and gratuity. So, upon such an application being filed, the concerned authorities of the trust will consider the prayer made sympathetically and thereafter pass appropriate orders, if possible, by releasing some amount towards leave encashment and DCRT. Is it DCRT, isn't it? Writ petition accordingly stands closed in terms of the above interim orders, if any, stands vacated.
Deeply obliged.
I'm for reference number 1.
Here we have recorded.
All right.
Item 19, perhaps I have to file an additional letter to bring about some recent developments.
The request of Mr. R. Mazumdar, matter stands adjourned, enabling him to file additional affidavit. Mr. S. Dr. appears for all India. Anyone else? Mr. A. Chakraborty for respondent number 2. Mr. Parajuli also.
Same.
Matter be deferred
My
by
lord,
2 weeks. How much time do you require?
I can file it by the next week, my lord. It will be taken up on the 2nd of April, my lord. I had a senior would also be here.
Listed on
2nd
of April.
My lord. Deeply obliged.
Wait, please. Well, pleadings are complete in these cases, in all these cases. And my lord, it's ready for hearing, subject to your lordship's.
It is already listed for hearing.
Yes. So should we proceed, my lord?
What is the issue about?
Well, it's regarding termination of 771 contractual employees of Assam State Transport Corporation. The issue is, madam, basically the contention of the state.
If you can complete within 1 hour, both parties are ready.
Lordship, the petitioner may start, Lordship, will give a reply on the next day, Lordship. It will take some time. There are many
Then
petitioners,
we will have to
Lordship.
defer it because this bench is not available. We don't want to keep it parted. If you can complete, we can finish it off.
Some calendar.
April, it will go to April. Unless Mr. Kumar is busy in April.
Lordship, the learned advocate general will appear in this matter, Lordship.
Therefore,
Lordship. But there are many
we'll keep it
petitioners.
on
2nd of April.
2nd or 3rd of April, whatever, or 4th of April.
4th of April, yes.
4th of April. Let us be listed again on 4th of April.
Lordship.
For hearing. For hearing.
I was ready, but I think it will not be concluded because
if you complete also, if we are not arguing, then we'll have to keep it parted.
yes, madam, there are several other councils for the petitioners also, but
Don't want to do that.
we are obliged.
Anyone for part 2?
Item number 2 of the part 2 list, Lordship. My client has instructed me not to praise the matter.
Item 2,
WBC number 1.
as per instructions of the learned counsel appearing for the petitioner, who submits that the petitioner is not inclined to press the writ petition, the same accordingly stands dismissed as not pressed.
Obliged.
Okay. আমি একটা কাম করবো, you come and meet me for the bail.